Good afternoon and welcome to the Appellate Division, First Department. I'm about to call the calendar. I will indicate that based upon your initial requests for time, we have over 7 hours of oral argument. So what I'm going to ask that you do is when I call the calendar and you give me the time that you're requesting for argument, please only request what you really feel that you need. And we'll take it from there. We do have your briefs, and we've had them for a while, as well as the records on appeal. So I hope it'll be apparent that we're fairly familiar with all of your cases. All right, the first case is People versus Riley. Submitted. Basil versus Law Offices of Neil Brickman. Did you ask for 3 and 1? Yes, Your Honor. And you asked for 15? Okay, I'm going to give you 3 and 1 and 3. All right, there's got to be some symmetry here. Okay. Gemmo versus William Doyle Galleries. 13. I don't know. Okay. I'm asking people to ask for what they reasonably need. Okay, and do we have a respondent? Okay, I'm going to give you 5 and 2 for the appellant and 5 for the respondent. Murphy versus Harris. The appellants, you have very similar arguments, don't you? Perhaps overlapping? Okay. All right, so I am going to give each appellant 3 minutes and 1 rebuttal, and I will give respondent 5. People versus Castillo. 6, 2, and 5, thank you. 21st Mortgage Corp versus Lynn.
Appellant, 7 minutes, please, Your Honor.
Do we have a respondent? Do you still want to argue?
I'm submitting, Your Honor.
Okay, thank you. Submitted. AVR Powell versus American States. Submitted. People versus Duran Infante. Submitted. Pura versus Air and Liquid Systems.
Appellant, 5 minutes, Your Honor. Respondent, 3.
5 and 3, thank you, counsel. Severny versus Severny.
Appellant, 7 and 2.
Respondent, 5 and 2 for appellant, 5 for respondent. 3710 114th Street versus Chen.
Appellant, 4 and 1, please. Respondent, 3 and 1.
You don't have a cross appeal, do you? You do? Okay. You do. Right, that's right. Okay, 3 and 1, 4 and 1, and 3 and 1. Thank you, counsel. People versus Estevez. Submit. Schwartz versus Genfit.
Appellant, 5 and 2.
5, 2, and 5. Thank you. Polonia versus 14 Sutton Tenants.
Appellant, 4 and 1, Your Honor. Respondent, 14 Sutton.
I'm sorry, I can't hear you. Say again.
Court doesn't have any specific questions. We will rely on respondent, Central Construction Management, 5 minutes, Your Honor.
Okay. 4 and 1 for the appellant, 5 for Central. I'll give the co-respondent, I'll give you 1 minute just in case something comes up during oral argument. Okay. Matos versus Geraldo. Do we have a respondent here? Apparently not. Do you still wish to argue, sir? Well, what do you need rebuttal for? Who are you rebutting here? It's just you. I'll give you 3. Okay. Okay, Castillo versus West End Towers.
Appellate 5-2, Your Honor. Respondent West End 5-2, Your Honor.
5, 2, and 5, thank you. Kavanaugh versus Hayes, that's a submit. And Feiner and Lavey versus Sohar is a submit. First case for argument on the calendar is Basil versus Brickman.
Good afternoon. Please the court. Sorry.
You can proceed.
Ben Oxenberg from Furman, Kornfeld, and Brennan on behalf of the appellants. The motion court decision should be reversed for 3 reasons. 1, the claim has been time barred since April 8th, 2018. 2, there's no breach of duty because the appellants received no notice of the subject bankruptcy through no fault of their own. And there is also no proximate causation because the underlying judgment debtor simply did not have assets on which the judgment could be reasonably satisfied. With respect to the statute of limitations, the respondent admits that the claim accrued on April 8th, 2015. So prima facie.
But isn't then the question whether or not there was a continuing representation which told the statute of limitations?
Yes, that is the only question, Your Honor. I'm sorry?
But a significant one.
Well, yes, but as stated in our briefs, we don't believe that the respondent has met their burden to demonstrate this. For example, you can't revive a claim that's been...
Just so I'm clear, this is a pre-answer motion to dismiss, right?
Yes.
So we don't go into burdens there, right? I mean, they're making allegations, correct?
Well, once a prima facie case has been established, the burden does shift to the respondent to show that the continuous representation doctrine applies, and that they have not done that. They can't point to any email in the record earlier than August 2019, despite respondents' claim that he regularly communicated with appellants over the previous 9 years. And specifically these post-statute of limitations emails show that the parties were discussing terms of a new representation. The record, page 358 to 360, shows that the appellants were offering to be retained on a contingency basis to pursue the judgment. So this is a new representation.
I thought that was for another case.
I'm sorry?
I thought that was for another case that they were trying to bring them in on for representation.
No, Your Honor. So in the interim period of time between August 2011 and August 2017, there was a separate representation that had nothing to do with this particular case and this particular judgment. It's well known in professional liability circles. It's Gallet, Dreyer, Berkey against Basil. So again, that had nothing to do with this case. And again, they were discussing terms of...
Couldn't you simply send a letter to the client and say, okay, you know, our services are done, we can't do anything further, and that's the end of it? I mean, that would have been clear, slam dunk, documentary proof that your representation was severed at that point.
Well, Your Honor...
But instead, we have all this sort of like back and forth flowing, you know, having, at least from in my mind, I have to start assessing whether or not your version of the facts is accurate and the plaintiff's version is not.
Well, Your Honor, I think the record's clear, and we did offer to submit all of the emails that we had with the respondent in the lower court in camera. Obviously, we couldn't breach our confidentiality duties and file those publicly, but I think the record is clear that...
Yeah, but I don't really understand that, but that's okay. I mean, it's the confidentiality is for the client who is suing you. So you know, there's a work around that. So I don't think that's the problem. And you don't offer documents. It's not up to the court to decide what you put in and what you don't put in. But all right, let's hear from the other side.
Thank you, Your Honors.
Good afternoon. May it please the court, Diane Bradshaw. Bradshaw Law Group for respondent. It's Frank Bazile, actually, is how he pronounces it. So Your Honors actually seem to have been making my argument for me, but I would point out that the...
Maybe not.
Well, the continuous representation doctrine does indeed apply, and it is appellant's position that these emails are beyond the statutory period or any other applicable timeline is unavailing.
Yeah, I mean, your client makes the allegation, says, look, he makes the inquiry about when the deposition of the judgment debtor went forward. She has no assets. I'm going to plan on file for bankruptcy. Your client states in his affidavit, look, I asked the law firm, said, you got 20 years to collect. I call him every now and then to find out what's going on and so forth and so forth. That's sort of the allegations are there. And then you have the defendant saying, well, no, this is what happened. But that's beyond the pleadings at that point.
Well, it's the substance and tone of the communications, not the date.
Right. But in any case, this is a pre-answer motion to dismiss, right?
Exactly.
Well, the date is bearing on something. I mean, it's got to be, in order to have continuous representation, it's got to take place before the statute of limitations actually passes, that it produces the forbearance, right?
Yes, and there
Okay,
was...
So timing is important.
Well, my client has informed me and would be ready to swear under oath that he had telephone conversations and that there should also be emails. My client's email base was actually destroyed due to...
I know that's the claim. I mean, it's kind of an interesting case in this. It's your client doesn't have the documentation to support him.
Any earlier.
The other side has in-camera documents that they never submitted. But in fact, we're still dealing with a motion to dismiss.
Exactly.
I mean, so it may be your client may never be able to prove continuous representation, but it doesn't sound like it necessarily gets thrown out at this time.
This is exactly our point. It's too soon.
So, counsel, how do you respond to the allegation that you can't prove damages because
we actually have engaged a forensic investigator, and just the least little bit of Googling produces evidence, which I have today, but of course it's outside the record.
Where's our record, right?
But our investigative resources have turned up evidence of current assets, and that is exactly our point. The underlying case was based in fraud. This is a grifter type of person, and
Yeah, but even if the debtor had assets now, if they didn't have assets sufficient to cover their debts at the time of the bankruptcy, that's really the period that you have to look at, because then the discharge was appropriate.
except, Your Honor, that the discharge would never have happened, or arguably would not have happened, because the underlying action sounded in fraud, and we would have had an adversary proceeding, and the debt would not have been discharged, or very, very likely would not have been dischargeable.
Okay. All right, let's hear from your adversary on rebuttal. So is this a case where it's like no fine wine before it's time? Is this just premature for us to be considering whether this is a good action or a bad action without further development of the record in the case?
Well, Your Honor, I don't think so. And there was an additional argument that we haven't touched upon yet, and that is that there was no breach of duty. Through no fault of my client's own, he didn't receive notice of the bankruptcy.
Well, how do we know?
I'm
How
sorry?
do we know that your client didn't play a part in that? I mean, if they we don't know about whether they did anything for forwarding mail from the one law office to another, whether they filed with the Department of State, whether they had an obligation to let the judgment debtor know because they were the attorney of record on the judgment before the bankruptcy was filed. I mean, how do we know what you're saying at this point?
Well, Your Honor, because it's reflected in the record. If you look at the notices themselves, they were defective and incomplete. They don't contain a business name, a law firm name, a
But
suite,
the
or a
notices
floor
weren't
number.
given out, weren't the product of Mr. Bazile, but because of the petitioner in the bankruptcy proceeding.
That's
So I
correct.
don't, can you hold that against him? And that also doesn't resolve the question of your duty. I mean, lawyers have duties when they move to make public disclosure of of their new address, and there's nothing in the record about whether or not your client did that.
Well, I understand, Your Honor, but the notices themselves were defective, and it is,
But isn't that in part, or couldn't that in part be because of the failure of your client's duty to make public the fact that they had moved?
well, I don't think so, because if you look at the other notices, they were all properly addressed. They contained full law firm names, suite numbers. There was no question that those reached the other creditors, but there was no
Yeah, but
possible
it would have
way.
been wrong under your scenario. It would have been wrong no matter what, because they had the name of the prior attorney, and they had an address. It was the address at the time that the judgment was obtained by your client, but your client moved.
That's correct.
Right,
but
so
there-
the fact that other addresses were correct is somewhat meaningless in this context.
Well, I think it's clear that the notices, there was no practical way for them to be forwarded by the U.S. Postal Service. And I understand.
How do we know that? I mean, that's a pretty broad conclusion.
I think we can see that just by looking at them, Your Honor. The addresses were incomplete. And I think that the court can take judicial notice of that fact.
Okay, thank you. Thank you
Thank you.
both. Gemmo versus William Doyle Galleries.
Good afternoon, Your Honors. My name is Robert McKay. I represent the plaintiffs' appellants in this matter. Just to place the matter in context, Margaret Riley became surrogate of Nassau County on January 1, 2016. At the time, there was a motion pending by Marianne Cassini's then counsel to withdraw as counsel for health
Yeah, I don't
reasons.
think we need to go through all of that because a lot of the history is laid out not only in the file here, but it was laid out in the Second Department decision, right?
Yes, it is.
So we know the procedural context, right? But what we're talking about is decisions or orders that were made by the surrogates court in 2018 about how to dispose of the estates, the Cassini estate's property, correct? I mean, that's when those are the orders that seem to be at issue here.
Yes, they are.
So weren't those orders issued at a time where even according to specifically according to the Second Department decision regarding these parties, the stay had already expired, it terminated. It terminated in July 2016.
Yes, Your Honor.
So the orders that were made in 2018 were valid orders, were they not?
No, they were not, Your Honor.
But you didn't appeal them. Your client didn't appeal them.
They were, the Doyle Galleries was not a party.
It doesn't
surrogate's
matter. The Doyle was hired by the receiver who had authority under those orders to otherwise dispose of that property by a certain methodology. And in fact, your client had agreed to it. Your client signed on to it. And said she wouldn't interfere with the sale of the property.
And she didn't.
And, well, that was her obligation. And there was, in fact, a procedure under the stipulations and orders that allowed her to object to the property that was identified as belonging to the estate. And she didn't do that, did she?
Well, she did. She submitted an affidavit with a lengthy list of the property items that she owned, together with an affidavit from her sister.
And when was that made in relation to when it should have been made?
At the same time, and in fact.
It was timely interposed?
Yes, Your Honor.
But she didn't go back to the surrogates court and said, aha, why did the receiver sell this property?
Sir, the two orders were issued when, after Surrogate Riley had placed Mary Ann Cassini in jail, okay? So it hardly gave her an adequate opportunity to present proof and evidence, although she did the best.
Did anybody ask for an adjournment? Was she capable of being represented while she was in jail?
Her counsel, Frank Sedio, who was a former surrogate in Kings County, submitted an order to show cause seeking a stay of the auction. And as had been Surrogate Riley's practice with respect to such orders to show cause submitted on Mary Ann Cassini's behalf, she ignored it.
So, but again, isn't your remedy a remedy of appeal to the Second Department?
I think.
It's like, why isn't this, why shouldn't we look at this as a collateral attack that is basically looking to do a runaround from the orders that were issued by the surrogate that your client disagreed with?
An appeal possibly could have been made, but I don't think that forecloses this action, which is not barred by collateral estoppel for two reasons. One, collateral estoppel requires a full and fair opportunity to present evidence, which was done, and the receiver, on the other hand, just said these items of property belong to OCI without presenting a single shred of proof as to.
But you're missing the procedural point here. They were just acting at the behest of the receiver in connection with what the receiver thought her duties were and mandate from the surrogate. If that was wrong, then isn't your remedy to appeal in the rulings of the surrogate rather than to do what looks like, quite frankly, an end run around the surrogate because your client believes, whether rightly or wrongly, that the surrogate just don't like her?
Well, I think rightly, but.
I'm not going to comment on that. I think perhaps you should tell her wrongly, but that's up to you. You advise her the way you want.
Your Honor, I don't know how the court could rely on a receiver's assertion of a belief in ownership without a shred of proof. Could an appeal?
You don't look at that here.
Could an appeal have been taken at the time? Perhaps, but I don't. Collateral estoppel is not foreclosed here because there was not a fair and full opportunity to present her position. And secondly, the issues were not determined. They have to be aligned with this action. And there was no issue at the time as to Doyle's breach of its duties as an auctioneer.
Okay, let's hear from your client. I mean, from your adversary. Sorry.
Good afternoon, Your Honors. Jeffrey Miller for the appellant. Judge, you had it exactly right. This is a classic Hornbook collateral attack on orders from the surrogate in Nassau County. And I'd like to clear up one part of the discussion that you had with counsel. The order, particularly the May 30, 2018 order of the surrogate, which is starts at page 23 of the record, laid out a process by which the receiver would declare which of the items would be sold. A list was then sent to Ms. Cassini. Ms. Cassini could object, which she sent a letter in objecting. The receiver said, I don't see any evidence here. I still believe this belongs to the company. And then the part that Ms. Cassini did not avail herself of is paragraph 5 of that May 30, 2018 order, which is on page 24 of the record, which says that if the receiver determines that the items disputed by Ms. Cassini are company items, and Ms. Cassini continues to dispute that determination, she may, within 5 days of receiving the receiver's determination, make an application to the court by order to show cause for an order determining the ownership of the disputed items.
And that was never done.
Never, not till this day, Your Honor. Instead, they brought an action in a different county challenging the company that actually just carried out the sale and not the underlying order, which was the basis of providing the items to the outside auctioneer company to sell them. If you have no further questions, I think that should resolve the issue on the appeal.
Any questions, colleagues? No. All right, let's hear rebuttal. Sure.
And perhaps, counsel, it would be helpful if you address the issue just discussed by counsel, that after Ms. Biamonte rejected your client's objections to the list, your clients had a right to go to court over that, and they chose not to do that. Why, if they chose not to go to court when they had the opportunity to do so, why would a collateral estoppel apply?
First of all, she was in jail at the time.
Well, but that, I'm sorry,
And,
that doesn't,
and secondly,
I'm sure that she had counsel who was able to speak with her while she was in jail.
Also-
Didn't she have counsel at that time?
she was, as far as I know, without counsel, except somebody may have come in at a certain point to represent her for a little bit. I don't know.
You're not claiming that she was held in jail in such a way that she was unable to reach out to counsel?
I don't know, Your Honor. I was not involved in the surrogate's court proceeding. There's one point that has not been mentioned yet, and that is putting aside everything else, the property items, and there were 315 of them, taken from her residence on East 19th Street. There was no court order that permitted that, nothing. So the Doyle should have been aware of that, and as a licensed auctioneer should have investigated the true ownership of those items of property and never did. And there was never a representation to the court by the receiver. An inventory of those items was requested several times from the opposition and was not provided. So at least that part of the action has to go forward because there was no authorization for the sale of those items. And I also believe that collateral estoppel, for the reasons I said, does not bar the entire action.
Okay.
Thank you very much.
Thank you. Thank you both. Murphy versus Harris. And we're starting with Appellant Satil. Dr. Satil?
Yes, Your Honor. My name is Nicholas Herzler. I represent Appellant Dr. Saltiel. Your Honors, the main point we want to get across here is that the statute has a 30-day cap in subsection A, which only allows the governor to suspend laws for 30 days as a maximum. There are a number of other subsections that we think limit the governor's.
Let's get to the core of this. There's already been two appellate divisions who have ruled the other way, that this is a toll, not a suspension. You are asking us to go another way. Let's start with, because the analysis in Brash was pretty substantial. Why was Brash wrong?
Your Honor, actually, this court doesn't necessarily have to disagree with Brash because, as it turns out in Brash, their limitations period was only 30 days. And as I said, there's a 30-day cap. So this court could hold, although we think it's wrong, but if this court were to hold that the governor had the power to toll, then that would he would only still have the power to toll for 30 days, consistent with Brash, because that was a 30-day limit in that case for the deadline to file a notice of appeal. We would still win this appeal if this court were to say that Brash was correct in saying there's a toll, but the issue before Brash was not whether the toll could extend past that 30-day period, which, as subsection A clearly says, not to exceed 30 days each, and every order must comply with every subsection A through F. So how is that consistent in any way with a toll that extends for 228 days? If the legislature had intended that, they would have
Yeah,
included.
but the plaintiff is not getting 228 days. The toll, is my understanding is whatever you have left, it just stops the clock from ticking. So if you had like 5 days left, once the clock starts ticking again, you only have 5 days. You don't have 228 days. You have 5 days. Am I misunderstanding the concept of toll?
Well, Your Honor, the way that the plaintiff is interpreting it is that because of the fact that they didn't file until February of the following year, 2021, that they're saying that they get 228 days beyond November 3rd,
Well,
2020.
I mean, the question to me is, how much time did they have left on March 2020 when the governor signed that order? I mean, whatever time they had left, that's when the clock stops at that point, right? So.
But the executive law says that the governor can only extend in 30-day increments, and he stopped on November 3rd. So how could they get another 228 days?
I'm not looking at 200, I'm looking at how much time they had left when the toll actually started. That's what everyone's talking about the 220, they're not getting 228 days. That's what I'm saying.
That's how the plaintiff calculates, Your Honor.
Oh, okay.
Yeah, but even if you calculate it, so in the way my colleague suggests, then it's still timely if it's a toll. In other words, they just get the benefit of what's left from the day that the toll ends on the running of the statute of limitations. If it's let's just say, if it's a 3-year statute of limitations and the toll starts when 2 years have evaporated, then at the end of the toll, then there's a year left.
Well, Your Honor, then
Wouldn't it be timely if that were the correct way to interpret this? Wouldn't the actions be timely?
Well, I think what Your Honor just articulated would be like a regular, similar to an insanity or an infancy toll. And what we're saying here is that the governor doesn't have the power beyond 30 days after November 3rd. And also, it would be a suspension because
You can't do sequential 30 days.
But he stopped after the governor ended the last one on November 3rd, so it came to 2020, and they didn't file until February of 2021.
Justice Gish, if I may.
You may.
Okay, so there's an initial March 20th, 2020 executive order, but then there were 8 additional periods, and those periods did not extend 30 days.
They were each in 30-day increments from March 20th until November 3rd.
That's appropriate.
Sorry?
That is appropriate.
It is appropriate, but what we're saying is the statute, the executive law says it can only extend in 30-day increments, and he didn't extend it past. He only had one order that expired. The last order expired on November 4th.
So then you are saying essentially it was a suspension and not a toll. Because
exactly.
if it was a toll,
right.
So your argument is exactly, it has nothing to do with 30 days. You're saying the statute of limitations was suspended until the day after his last order. And that's not what Brash says or what the Third Department has said. So you are asking us to disagree with our sister departments. Right? Both of them clearly say it's a toll, which would be the period, the time essentially stops on day 1, and then it starts again at the end and goes and ends out, correct?
Yes, we're saying that, well, obviously under subsection E, a minimum deviation would be a suspension and not a toll. We are arguing for a suspension, but what we're also saying is, even if it's a toll, because of subsection A, it can't go beyond more than 30 days. Because
even how about all the subsequent executive orders? Each order tolled for 30 days. So you add them all up, that's it. You're saying that the governor only had one shot to do a 30-day toll?
No, he could do as many 30-day increments as he wanted.
Didn't he do that? And isn't that exactly what he did?
He did but then he decided to end it on November 4th.
Exactly. So the toll started on March 20th, ended on November 3rd. You are saying, actually, even though you're trying to couch it a different way, it's really a suspension and not a toll.
We're trying to argue both, Your Honor, but obviously.
But I don't understand how you could say there's just one 30-day toll, because there's clearly subsequent tolls.
It's an argument in the alternative. We're arguing it's a suspension, but even if it is a toll, that it couldn't go beyond the last order because he has to do them in 30-day increments.
So how is that a toll? That's a suspension. It's not a toll. I mean, literally not a toll.
Because the Brash court said that it was a toll, but only for 30 days past November 4th. That's what, they didn't say only, but I don't want to say that, but they did say 30 days past that because they had 30-day period in there.
Well, that's just because the facts of Brash, that was what they were dealing with. It certainly, the implication of it isn't that anything beyond that wasn't a continuation of the toll or a 30-day continuation of a toll.
I'm not saying that they implied anything. I'm just saying that they're holding.
Well, you said we could make them consistent, and I don't understand how. I'm trying to understand. You know what? You'll have some time in rebuttal. Let's hear from your co-appellant who has very similar arguments to you. Maybe they have a perspective on it.
Thank you, Your Honors. May it please the Court. My name is Megan Lawless, and I represent the Appellant Imaging on Call, LLC, in this action. I agree with the Court that between March 20th and November 3rd of 2020, there was a series of 30-day suspensions, each permissible.
Well, you're not agreeing with us.
No, none of us said there was suspension. There was a series of 30-day orders.
30-day orders, excuse me.
The issue is whether they were suspensions or tolls.
Yeah.
I
Be careful
apologize.
what you agree with us on.
I apologize. There was a series of 30-day orders which were completely permissible based on the plain language of the executive law, which allows laws to be modified or suspended for 30 days at a time, and they can be renewed every 30 days. So all of those executive orders consecutively were permissible. I would argue they act as a suspension. They cannot act as a toll, because what it effectively does as of November 3rd is allows upwards of an additional 228 days to be tacked on to the end, and that runs afoul of all the various limitations in the executive law. And with respect to this case,
well, the 228 would only be if, in fact, the cause of action accrued on the first day of the executive order.
well, yes,
Right?
well,
most what it's really affecting is the cases where the statute of limitations is running during the period of the executive orders. Those are the cases that are affected by this, and only those cases.
correct, Your Honor. And this is, in fact, a case that is directly affected by that.
Clearly.
The wrongful death cause of action expired by its natural terms September 30th, 2020. The medical malpractice expired on November 10th, 2020. So for that med mal action, a full 228 days would run between March 20th and November 3rd, and tacked on to the end of that expiration period, the wrongful death gets an additional 194 days if this court were to interpret this as a toll. So it does have the ramifications of a very long extension in this case.
It could possibly, right.
Yes, and the problem with that is, and I do think
So
with
is
all...
it your position that Brash and the similar third department case were wrongly decided?
Yes, yes. I do think that Brash...
Could you explain why?
I think that they had a limited set of facts in front of them. They were only dealing with the 30-day extension, and they only looked at one of the limitation periods, standards and limits, subsection D. They basically limited their analysis...
So they were misled by that to reach a wrong result?
I'm sorry, excuse
Are
me?
you saying essentially that they were misled by their unusual set of facts to reach an incorrect result?
I don't know, but if you look at the executive law and the various subsections under it, it says any suspension must comply with each of these subsections. It's not either or, it's an and. And the Brash court and the third department that followed its reasoning only focused on one of those subsections, and then that's D. And they said subsection D allows the governor to not only suspend, but to modify a law. A toll is a modification, therefore that can be done. But they did not discuss the 30-day time limit. And I think that's what my co-counsel was explaining, that a 228-day block amount of time, toll, added after the initial 228 days, that is what runs afoul of the 30-day limit.
But I'm listening to your argument here, and the argument is premised on the fact that you have this 228 days that you're saying is going to be tacked on for the plaintiff to commence an action. What if I go back to the earlier position I had, you're not going to get the 228 days or however many days that toll is, because the governor can every 30 days issue an order, an executive order. That's not a problem, right?
Correct.
He could execute 130-day orders, right? Right? And the argument is we're tacking on all that period of time to allow the plaintiff to. My thinking is that under the tradition of the insanity toll, whatever toll that's out there, you only get what's left when the clock starts. So if you have 1 year left, once the clock starts ticking again, you only got 1 year to go. You don't have that entire however many days are in between the tolls.
Correct, but in this case, if you go by what the Brash Court defines as a toll, as you take the 228 days between March and November, and you add that on to the end, this plaintiff would indeed have an additional 228 days.
So what? I mean, there was a pandemic going on. The courts were closed. You couldn't even file a new lawsuit, even if you wanted to. So the governor, acting under the executive law, 30 days at a time, figured that this was a reasonable response in light of the emergency and the fact that the courts were not in operation. Why wouldn't it make sense for the statute of limitations in that narrowly defined category of cases where the statute of limitations was running during that emergency period to have additional time to file cases, and also that it not be calibrated so that all of those, whatever those cases were, had to file in the courts on the same day. I mean, to me, I just don't understand why this is such a decision that doesn't have a policy behind it, or is so against public policy that we shouldn't allow for a toll. I just don't understand the argument. So what?
And on top of that, it's only a 3-month. I want to make clear, it's 3 months later, right? I mean, it wasn't like the plaintiff waited a long time before they commenced an action against your client. It was 3 months later. It was like in February of 2021 that the causes of action came down. So we're talking about a small period of time.
Yes, correct.
But under your theory of suspension, then they would have been out right off the bat. Once November 4th came in, that's it. They're out of luck, right? Because the suspension, you're saying, the clock's still ticking.
Right.
There's no time at all to commence an action. That doesn't sound correct, right? Because if you think about it, like my colleague says, during that period of time, they couldn't file an action anywhere. The whole court system was shut down. And then on November 4th, when they can actually run to court, they're out of luck? That doesn't sound right to me.
And how would you justify those executive orders then, which would just bar everything that was pending at the beginning of the pandemic?
But I don't think they would. See, the courts opened back up for e-filing in May of 2020.
No, we're talking about reopening in November when the last executive order expired.
Right, but
but is it actually your position that on the day the last executive order expired, that nobody could file a lawsuit that had been in the process of getting filed or had time left on its statute of limitations at the beginning of the pandemic?
No, I think that anything that expired during that 228-day period was then extended through November 3rd.
So then they had 1 day.
1 day.
Yes, but in this case,
Is that
1
what
day.
Are you really saying that they would have 1 day from the expiration of the last order?
the previous order.
Is that what you're saying?
Well, yes, yes and no. If I may,
It's either one or the other, I don't know.
the previous order prior to the final one said there will be one more after this, and it will expire on November 3rd.
Right.
So it's not that litigants didn't know this was coming, and in this case, we're dealing with an amended complaint.
But whether
The
they
original
knew it was
complaint
coming
was
or not,
filed on November 3rd.
is it your position that on November 4th, they were out of luck? Or that was their one day?
It didn't have to be one day, though. If your statute of limitations expired prior to November 4th, then you had until November 4th to file it. If you had 3 years, 2.5 years, 2 years.
Do you have any conception of the burden that, if your interpretation was right, the burden that may have placed on the court system to take in all of those cases on a single day? Is that good administration? Does that mean that, does that give effect to the executive orders, which were actually meant to kind of, in part, to ease the burden on the courts, which had not been open?
But there was no need to wait until November 4th. The courts were open days and months earlier.
You said something very interesting. You said if your statute of limitations expired during that period of time of the executive orders, right? Okay, from March 20th, 2020 to November 3rd, 2020, if your statute of limitations ran in that period, you only had November 4th to commence an action, right? That's what you said.
Correct.
Okay. In this case here, correct me if I'm wrong, plaintiff's statute of limitations did not expire in that period of time. There was still a their statute of limitations, they still had time left when the first executive order came down.
The wrongful death had expired. The medical malpractice action had not expired. Correct. So that expired on November 10th. So they had, between November 4th and November 10th, they did file the original complaint here on November 3rd, not knowing which way it would go, out of an abundance of caution. This amended complaint was filed after the fact. But again, the courts were open in May.
But it's just not that. It's not that the courts were open and you could e-file. You still have to serve. So what you're saying is every person, and I think even at that point we hadn't had a vaccine, that all the process servers were supposed to go out in November and serve, even though we didn't have a vaccine by then, and there was literally no way to actually, because obviously affecting service isn't just filing, right? You have to actually serve. So you're saying...
I'm going to add that the courts were not fully functioning with their full clerical staff at that time. There weren't clerks to even process this stuff.
I think that the problem here with interpreting this as a toll is, I think in the most, I don't want to say, I don't know the right word, but let's say a breach of contract case that accrues on March 1st, 2020, naturally expires 6 years later. To add 228 days, how does that make sense with respect to the pandemic response to COVID that many years later? And that's where I think a plain reading of the executive law needs to come into play to fully understand what limits are placed on suspensions and how a blanket toll in every case...
I'm not sure that the executive law isn't designed, at least in some regard, to allow the governor flexibility to deal with emergency situations unanticipated, like a pandemic, that have a monumental effect on the court system. But let's hear from your adversary.
Good afternoon. I'm going to try to be quick on this. Court's completely right. They're trying to couch an argument with this 30 days. They conveniently ignore Executive Order 29A, which says specifically the 30-day period merely states that every 30 days, the governor then, on reconsideration of the facts and circumstances at that time, can extend it another 30 days and doesn't limit the amount of times he can do that. The 30-day period is just to make sure...
They're arguing, they're arguing that by under Brash, you're getting 228 days added on to your statute of limitations. Do you agree with that?
No, that's not, it depends on the circumstance of the case. Essentially, there is no question that the governor intended to create a toll. We know that for two reasons. He uses the word toll. Toll has a specific meaning. He then, at the conclusion of it, says it has tolled all these actions for this period of time. So there's no question that was his intent.
And let me just ask you, do you agree that the governor does have the authority to do a toll?
Absolutely.
As opposed to a suspension?
Absolutely. 29A, which provides him with the executive authority, specifically says that he can suspend and modify. That is the clear cut. By the way, the term suspend was not referring to statute of limitations. It was referring to suspending the operation of a statute. It could deal with statute of limitations, specific statute of limitations statute, but it could deal with speed limits.
Parking, right, parking
anything.
restrictions.
The term suspend, by the way, which the defendants continually utilize, has an ambiguous meaning in the law. It's been used as a toll. Even this court has used the word suspend interchangeably with the word toll. What is clear, he intended a toll. What is clear, 29A allowed him to modify the statute to make a toll. And what is clear is that that toll period, we're not saying the toll period happened after November. The toll period happened between March and November. That is the period of time he temporarily changed the law to remove the period of time, which made perfect sense in the fact that we were under a pandemic, circumstances were different. This was different from the prior.
Yeah, that period of time doesn't count. That period of time, the 238 days, cannot be added to your statute of limitations. That's all. You're not saying I'm going to take that 238 and add it on the other end.
All that's added to mine is the period of time from the time the toll began.
What you got left?
Whatever day that is.
Whatever was left.
What was left. Exactly, like any other case.
Okay,
Thank you, Your Honor.
thank you. Okay, let's hear rebuttal.
Your Honors, the court obviously, I think, believes that a toll is good policy, and it's just our trying to make the point that
Don't make assumptions.
that-
We ask all kinds of questions.
it's not the court's role to make policy, it's the legislature's
Well, no,
decision.
and that's why you're misunderstanding, and that we're like, we didn't say that. We said the governor instituted a policy under the circumstances that existed, and you can't say it's irrational.
We're not saying-
I don't know what policy any one of us would make if we were the policymakers, but we can't get behind a policy that was invoked by the governor, which seemed to make sense given the circumstances, and pit that against your argument that somehow 228 days added on is per se unreasonable and should be illegal. I don't really... I really think that you have misstated what we said.
Your Honor, I didn't mean to misstate what the
I don't
court...
think you did, but you did.
Your Honor, what we're trying to say here is that, as the Brash Court said, the governor's authority stems from the executive law. His power is limited under the executive law. It says minimum deviation in subsection E, excuse me.
So
it's a very restrictive...
You're just saying he does not have the authority.
He doesn't have the authority, and even if the court thinks it's good policy, it's the legislature's role.
I guess the problem I'm having is your use of the phrase extended the statute of limitations by 228 days. The statute of limitations remains the same. The only thing that changes is when you start counting from. So if your statute of limitations is 4 months and there were 2 months remaining at the time that the pandemic began, then it would still be, you'd have 2 months at the end in November. If you had 5 years left, then you still have 5 years left when the last executive order expires. So I don't think that I think your phrasing of the statute of limitations being extended is the problem. It's not that it's being extended, it's being suspended for that period.
I understand what Your Honor is saying. What I'm trying to say is that the legislature, when it passed the executive law, said that the governor can only do this for 30 days at a time, and he doesn't have the power to toll for the amount of time that they're claiming, even if, however much time that they claim that it was a toll, and they didn't use the word toll in the executive law, as the Brash Court noted.
Okay. All right, let's hear from your co-appellant.
Just on that last point, Your Honors, I think it's this 30-day limit, and why it's relevant is because when you put together the amount of time that can be upwards of 228 days, the executive law simply does not allow for that in the practical application of what it means here. And when it talks about minimum deviations, it's how can we minimally deviate from what we, the legislature, have decided is an appropriate statute of limitation to address the COVID-19 emergency. And interpreting this as a toll with such far-reaching impacts on all types of limitation periods throughout the state in ways that we probably haven't even been faced with yet, I think it has very far-reaching consequences that were simply not authorized by the legislature when it passed the executive law. Thank you.
Thank you. Thank you. Thank you all. People versus Castillo. You may proceed.
Good afternoon, Your Honors. May it please the Court. Anjali Pathmanathan on behalf of Mr. Castillo. I'd like to focus my arguments on point 3 of my opening brief, the lower court's failure to charge the justification defense. In this case, the trial court committed the reversible error when it failed to charge the jury with the justification defense upon counsel's request. The law is unambiguously clear here that the court is required to charge justification if there's any reasonable view of the evidence in the light most favorable to the defense that shows that the jury might have decided that Mr. Castillo's actions were justified. Justification is an ordinary defense, not an affirmative one, and so it has the broadest possible scope. And the trial court must charge it in every case whenever there's evidence to support it. So here, the justification defense was clearly supported by the evidence in the light most favorable to Mr. Castillo.
What impact, if any, does the fact that the evidence indicated that there were 4 additional shots from your client's weapon into the victim's back, how does that bear upon justification?
Your Honor, that's a question for the fact finder. At the end of the day, that same witness, Denny Garcia, is the only eyewitness testimony that is presented by the prosecution in this case. And leading up to the gunshots, she specifically, unambiguously testifies that Mr. Castillo enters the salon first. He's followed by the decedent, who physically...
But there's no dispute that the victim was shot 4 times in the back.
There's no dispute that the decedent was shot...
You don't need an eyewitness for that. They had an autopsy. They had proof. They had proof. He was shot in the back.
Right, Your Honor, but the issue of how the decedent was shot has to...
Well, I guess, let me be more pointed.
Okay.
Can there ever be a justification defense when the defendant shoots somebody in the back?
Your Honor, the issue here is that the people's testimony is not consistent. We have an eyewitness saying that Mr. Castillo and the decedent were standing face to face. And at that moment...
But counsel, this same witness, I'm sorry, Justice
Go ahead.
No, this same
I'm
witness
making my point.
indicated that defendant, he immediately moved away. So that means he was able to retreat.
That's a mischaracterization of the record, Your Honor, and I'm glad we're pointing it out. Denny Garcia specifically said that at the moment that the decedent placed a razor blade against Mr. Castillo's cheek and said, "I'm going to cut you from ear to ear," Mr. Castillo stepped back and shot him right away. That's the testimony. It is not that he stepped away, far away from the decedent where he could go anywhere in complete safety. And if you look at the images of the salon that were submitted into evidence by the prosecution that are before the court, There was nowhere for Mr. Castillo to go.
But the fact is that after that, the autopsy shows that the further shots shot by your client were in the victim's back. And in that context, I was really looking forward to your answer to Justice Gish's question, which you did not answer.
Right, so I was going to
I would
answer it,
really
Your
like
Honors.
to
The
hear
issue
your
here is
answer to
that it's an extraordinarily low burden. If there's
Can
any
you just answer the
reasonable view.
question? The question is very simple. Can you ever have a justification defense when the victim is shot in the back?
Yes.
How?
Because the situation we have here is we have to look at all of the people's testimony. The people's testimony here from Denny Garcia is that she views the decedent standing directly in front of Mr. Castillo when she hears the first 2 gunshots. Then she sees the decedent's body turn, and then he gets shot in the back. Now, that's corroborated by the autopsy evidence that establishes that one of the gunshot wounds was on the left side of the back body and the rest were on the back. And when you look at Dr. Landy's autopsy testimony...
Counsel, isn't the medical examiner's opinion that he died from the shots to the back, correct?
That's correct, but that has nothing to do...
Wait. And you're only entitled to use deadly physical force in the face of deadly physical force, right? So after he shoots him twice and he turns away, what he does when he kills him, he's not subject to deadly physical force, is he?
That's not the standard, Your Honor.
Tell me, what am I missing?
The standard for getting the justification charge before the jury is just if there's any reasonable view of the evidence in the light most favorable to Mr. Castillo.
Right, we all agree that.
Right.
You can read, we all read the Court of Appeal, but I'm saying, how could he be justified shooting him in the back and killing him when at that point he wasn't faced with deadly physical force?
At the time that the gun was shot, Mr. Castillo was facing the threat of deadly physical force, a fact that the prosecution has never denied. That's in the record. Now, the question here is what the fact finder would have found had they been able to deliberate on the justification charge. It's not for this court or the lower court or the prosecution to engage in the fact-finding process that the jury should have decided. Now, the point here is with justification defense.
It wasn't a real fact. I mean, there was no dispute. He was shot in the back 4 times, and that was the cause of his death. That wasn't disputed. And so it is really, the court is the one in the first instance that has to decide if there's a reasonable view of the evidence that would put the issue of justification sufficient for a jury. So, I mean, you're begging the question in a way whatever. I don't know that it was for the jury. Certainly the lower court didn't think it was for the jury.
Your Honor, I'll just point out that every single case from the Court of Appeals establishes that if there's any reasonable view of the evidence in the light most favorable to the defense, they have to get the justification charge.
We understand that. But
right.
I don't know how you can argue that it's a reasonable view of the evidence that shooting somebody in the back 4 times is justification. That's the problem here.
Right,
if you're
but
right, then he gets a new trial. If you're not right, that this can be determined as a matter of law, as the lower court thought, then that's it. Okay,
there's just
let's hear from your adversary.
Okay, thank you.
Good afternoon. May it please the court. Cynthia Carlson for the people of the state of New York. The defendant in this case shot a fleeing victim multiple times in his back, killing him. As this court
is it possible that the justification defense could have applied to the first 2 shots?
No,
to the victim? And would that make a difference?
To the extent that does justification apply to the first shots that are fired? No, because in the testimony of Denny Garcia, which we have to look at as a whole, this court has said in People v. Frazier, you cannot base a justification defense on a dissection of one witness's testimony. And in this case, on page 918 of the transcript, Denny says that when the victim comes up to him with a 1 5/8 of an inch razor blade, holds it to his face, the defendant steps back. She then says that the defendant at some point pulls out a weapon, fires. There's no indication.
Is there any other evidence that would contradict that testimony, that when he pulled out the razor blade, he stepped back?
There is no other evidence that refutes it, is unrefuted. And in fact, as defense counsel points in their brief, even the evidence that the medical examiner found, there was no stippling, there's no gunshot residue on any of the clothing that the victim had that was vouchered, that the ballistics evidence, that there was only one gun, and the medical evidence that the autopsy report reflects, all these wounds were to his back, except for one, that one was to his arm and was consistent with the victim, as the prosecutor noted in summation, trying to cover himself as he's turning. This was an abatement. That threat no longer existed the moment the defendant put his finger on that trigger. As the Court of Appeals has routinely said, justification is a defense of last resort. That's not what happened here. This was not last resort, and for that reason, Justice Neubauer was appropriate in denying the defense request.
So is there any evidence in the record that the first shots, be they one or two, in any way caused or contributed to the victim's death?
No, Your Honor, there's not. Dr. Landy testified, as well as the photographs from the autopsy report, and the autopsy report itself were introduced into evidence. And everything suggests or establishes, doesn't even suggest, it establishes that the fatal bullets wounds were 2 to the back and 1 to the side. Based on the testimony, that side shot had to have occurred when the victim was turning.
So, counsel, under your analysis of the justification defense, it can never be employed when the fatal shots are shot into the back of the victim.
No, because what threat exists? It has to be both objective and subjective, and there is no objective or subjective view of the evidence that supports this idea that as a victim is fleeing, they are still a threat to the defendant.
And how do you deal with the fact that the victim is the first aggressor?
Because the victim is the first aggressor doesn't mean that the defendant is then automatically entitled, when he's not in his home, to automatically use deadly physical force. Again, you can have an initial aggressor, but the moment that the initial aggressor no longer presents deadly physical force, then the defendant is not entitled to use deadly physical force against the initial aggressor.
So your view is that even though this victim was the initial aggressor, once the defendant stepped back and shot, there was no more threat of imminent physical force?
Correct. Okay. Correct. I would also just note, even if this court believes that it was error, a new trial is not required because the evidence overwhelmingly established that this was not a justification, that the justification of defense does not apply in this case. So either way,
I don't know how you separate that. I mean, either if the defense applies, if we find it was error, then I don't think it could be harmless. But if it doesn't apply, then everything is good.
Well, the courts have said that it can be harmless, especially in this case where defense argued it on appeal. It's not like it wasn't argued before the jury that they had this information. And the information was that the victim was shot in his back. If there are no further questions from the court, the people will rest on our brief.
Okay, thank you. Okay, rebuttal.
Your Honors, I want to clarify a really crucial part of the medical testimony. Dr. Landy was specifically asked whether the decedent was moving and the gun was still, or whether the gun was still and the decedent's body was moving at the time that he was shot, or both. And she said it can be any of those things, and you cannot tell by where the gunshots entered the decedent what the body was doing or what the gun was doing, meaning the person holding the gun was doing at the time that the decedent was shot. Why that is relevant is because the justification defense doesn't require that the defendant has to commit the deadly shot in the first bullet that exits the gun. And what we have here is testimony that the decedent's body was turning, or the shooter holding the gun was moving at the time that 6 bullets were fired quickly.
Counsel,
This
do
is
you
not-
agree with your adversary's statement that it's undisputed that once the victim, who is the initial aggressor, pulled out the knife, that the defendant stepped back, that there's no other information or testimony that would contradict that?
The word step back, yes, Your Honor, but I want to contextualize what's happening. We have the decedent raising his arm and placing the razor against my client's cheek. If you step back from that, you haven't exited the situation. You've stepped 1 foot back. And what's the most important part of that testimony that follows right afterwards is that Denny Garcia says that my client shoots the decedent right away. On appeal, it's easy to make something seem like this was a really long engagement and there was a lot of back and forth and there was time in between each bullet. That's not the case, that's not the testimony. And if you look at the video evidence, from the time Mr. Castillo entered the salon and left the salon, it's some 25 seconds. So we're talking about an extraordinarily fast set of circumstances, and that's why we have the justification defense. It's not to say that the trial court or myself or the prosecutor or your honors can decide justification. It's for the jury to decide.
And let me
whether
just
or not-
ask, the defendant's lawyer did argue justification to the jury, correct?
He could not argue justification on his summation. And if you look at his summation, by hamstringing the defense counsel from not being able to argue the justification defense, his only possible argument on summation was that Denny Garcia must have lied, that this testimony that the decedent had a knife against my client's face and threatened to cut his throat was a lie, based on this concept of the narcotics, the alleged narcotics in the bathroom. And for the other points I raised in my brief, for your honors, in point 4, I talk about how that part of the defense had been curtailed in terms of cross-examination and the Confrontation Clause violation. So the jury didn't even have a lot of that information before them to adequately deliberate on this defense. And what all of that did is it undermined Mr. Castillo from having really any full defense presented. The standard is so low for the justification defense.
I'm going to ask you to wrap. I've let you go way over the light, so I'm going to ask you to come to a conclusion.
Sure, Your Honors. Looking at all of the Court of Appeal records for this issue, particularly pointing to People versus Steele, People versus Vega, this case has to be overturned because the justification defense should have been charged to the jury. The reasonable evidence based on the prosecution's only eyewitness established that the justification defense was required. Thank you.
Thank you. Thank you both. What? Yeah. Para versus Air and Liquid Systems.
Good afternoon, Your Honors. May it please the Court, this is Mike Tuttle from the law firm Foley Mansfield, appearing for appellant defendant Steel Grip Incorporated. This is a product liability claim that should have been dismissed in the Supreme Court, NICAL, for lack of specific personal jurisdiction over Steel Grip. The two-pronged question on appeal is first, whether the Supreme Court erred by not dismissing the complaint based on allegations against an out-of-state defendant, and second, whether the Supreme Court erred by granting respondent plaintiff's request to open Steel Grip to jurisdictional discovery. Assuming arguendo...
Right, so jurisdiction, if it exists at all, has to be under long arm, right? Your client is a non-domiciliary, right?
That's correct,
Right.
that's correct, Your Honor.
We've certainly had a lot of jurisprudence on that issue. Okay, so the issue, I guess, at least for me, is not whether there is specifically jurisdiction here, because we don't have a particularly well-developed record, but whether they make a sufficient start that would otherwise permit the court to have jurisdictional discovery to develop a factual record, right?
That's correct, Your Honor.
That's the matter of law. So why shouldn't we allow it in this case?
So, Your Honor, the Court of Appeals, in Peterson versus Spartan Industries is the case that should guide this court's opinion. That first, that a prima facie showing of personal jurisdiction is not required, but that what is required is that the plaintiff make a non-frivolous, plaintiff have a non-frivolous position before the court to order personal jurisdictional discovery. And it's our position that the record, which consists entirely of decedent's testimony, is not based on any personal knowledge of the decedent about where steel grip gloves.
Well, obviously, let's just say it's, I'm sorry, go ahead. It's got to be because you have discovery, right? So what else, what's the plaintiff going to put up? So that's the whole point here, right?
Sure, but I would direct the court's view to Lamar v. Klein, which in this court, in the First Department, the court ruled that the affidavit of the plaintiff in that case was not based on personal knowledge for the court to open up the defendant to jurisdictional discovery.
But here we do have personal knowledge. We have the plaintiff's testimony that he was given these gloves when he was in New York, when his ship was in New York, and that his employer, as he understood it, had storehouses in New York from which these were delivered to him. So to the extent he had, I mean, he knew that the gloves were given to him in New York, and that was the basis on which we can go on at this point. Why isn't that enough?
Well, if you look at the decedent's testimony, he was asked about how he would have known where how steel grip gloves came onto the Italian lines in New York. And his response to a series of questions in that vein was, I don't know, I worked in the boiler room, there were others that were in charge of getting the steel grip gloves. Well,
he also testified that when coming on the ship, it comes in a box, and the box has the name of the manufacturer, including steel grip. And he also said, you have a place because all the supplies we buy in New York City. It seems to me that on a pre-discovery motion, that the issue here is why shouldn't there be an opportunity for discovery?
Your Honor, the record of the decedent's testimony also goes on to say that he has no idea where these gloves came from, how they came
What does it
right.
matter? I'm sorry.
Go ahead.
No, but I mean, what does it matter? You know, he said that he saw the steel grip gloves being pulled out from the boxes. He specifically saw the boxes with the steel grip logo on them, that he used the gloves, you know, at his job. What does that matter?
Yes, Your Honor. The vessel sailed from Italy to South America and North America, and his job was in the boiler room. So he may have, purportedly, he used those gloves on the vessel, but how those gloves, whether or not those gloves came from New York, would be well beyond his personal knowledge.
Well, so isn't that interesting? Because you're in opposition to the motion. You said nothing about your sales of gloves in New York. You put in an affidavit from someone who said, we are here in Illinois, we don't own any property in New York, and we don't have a place of business in New York. Not that we never sell any gloves in New York, not that we never distribute any gloves in New York. None of that is in your client's affidavit. So wouldn't a better affidavit on your part have clarified that issue?
Well, Your Honor, I understand the question that a better affidavit would have been beneficial to my client.
No, but if you're saying don't even let us start, then the thing your client should have done is said, no, I never sold a single glove in New York. Because clearly, if you sell $8 million of gloves in New York, that's a good start for long-arm jurisdiction, right?
The plaintiff didn't take that position, and going back to the Peterson Court of Appeals case, the plaintiff needs to make a non-frivolous position, and this court had ruled in Lamar that it has to be based on some personal knowledge. The only evidence before this court in the record is the decedent's testimony of working in the boiler room, and the record makes very clear that there is absolutely no personal knowledge that the decedent would have had to know the provenance of where these steel grip gloves.
Yeah, but you know what, as my colleague says, all that information is in your hands. And now you're saying the plaintiff's got the burden when he doesn't know anything. But you guys got everything. You guys got everything. You have all the paperwork. It's simple enough that you made the motion and the plaintiff said, look, here's all the paperwork. We don't even come into the four corners of the state. But you didn't do that. And now you're shifting it, from what I'm hearing, you're shifting, well, the plaintiff didn't do this, the plaintiff didn't do that. But you got everything. He doesn't have anything.
Yes, Your Honor, I understand.
Unless I'm missing something from what you just argued.
Well, no, Your Honor, to respond to
Yeah,
your...
I'm listening to you. What you said.
To respond to your question, Your Honor, the case law makes clear, as I would advance, that it's up to the plaintiff to make a non-frivolous...
Ultimately, but it's up, you move to dismiss. It is your initial burden, not the plaintiff's. At the end of the day, it could be the plaintiff's, but it is your initial burden. And on your initial motion, you did not put in any affidavits saying that you don't sell those gloves in New York, or that that there's no warehouses that store that gloves. You didn't put any of that in.
Your Honor, I would just simply go back to the fact that there is nothing here in the record from plaintiff that would make a sufficient start. And I do see your point that an affidavit that included that information would have been beneficial in the motion to dismiss. But the simple fact is that the plaintiff has not made a sufficient start. In fact, it's a false start based on the fact that there's no personal knowledge at all to even establish jurisdictional discovery.
I think if you had said, we never sell any gloves in New York, then it would have been a false start. But since you didn't say that, and it could be, we have no idea, that you were selling millions of dollars of gloves in New York when plaintiff was in New York and using your gloves. We can't tell because you didn't put that information in your initial burden on the motion to dismiss.
Yes, I understand, Your Honor.
Okay, let's hear from your adversary.
Thank you.
Good afternoon, Jason Weinstein, Weitz and Luxembourg for the Pura family. Your Honors, these questions that still remain to be answered is precisely why it was appropriate for Judge Silvera to order jurisdictional discovery, which took place. In fact, a corporate representative from Steel Grip was deposed about 5 months ago now. And these questions, it's to whore the record on appeal, obviously. These questions were answered. It was appropriate to order this kind of discovery. Mr. Pura, in his deposition testimony, obviously had firsthand knowledge about what he discussed, which included
Did he have actual firsthand knowledge of where the storehouses were? I mean, or that there was a warehouse in New York at all? Or would it be fair to say that he only had firsthand knowledge that gloves were given to him in many places, including New York?
The firsthand knowledge he had as represented in the deposition testimony were that there were boxes of gloves repeatedly put onto the ships that he served on when they ported in New York. What he didn't know, and what I think a pretty close reading, or even a fair reading of the testimony, is that he didn't know what particular store the gloves came from in New York, but he knew that there were boxes of gloves loaded on the ship in New York, and that subsequently he would go to the storeroom, he would get new gloves, including gloves that he knew to be Steel Grip. So these questions about what store the gloves might have come from, what were the distribution chains, did Steel Grip directly send the gloves to New York, those are questions perfect for jurisdictional discovery, but we made the sufficient start based on Mr. Pura's testimony that there were gloves delivered in New York.
The jurisdictional discovery's already taken place?
5 months ago.
And is there any pending additional motion practice in the trial court as a consequence of that?
No, the defendant, subsequent to the jurisdictional discovery, filed this appeal and a motion to re-argue Judge Silvera's decision, but post-jurisdictional discovery and on the basis of that evidence as the record's been developed, the defendant has not put in a new motion to dismiss, although, of course, Judge Silvera denied the motion with leave for the defendant to go ahead and do so. So our prime contention is that the record is...
Even if we affirm, the issue doesn't go away.
That's correct. Yeah, the defendant will have another shot. This really isn't ripe to be before this court. The record has been further developed. Defendant, if they file another motion and Judge Silvera denies the motion, we'll be right back here on a further developed record for the court.
Right, I hope not, but okay, you know.
Well,
Not that it
I
isn't
hope
nice
so,
seeing you,
because it'll mean-
gentlemen, but, you know.
I hope so, because that would mean that Judge Silvera would reject the
Well,
motion.
I don't know, we don't know what's going to happen, but things are moving forward. Right, okay, all right.
Thank you.
Thank you both.
He didn't take his time.
Let's see. Severny versus Severny?
I know.
Good afternoon, and may it please the court, Your Honors. My name is Scott Benjamin, and I am here representing the appellant, Andre Severny, in connection with this appeal. I want to narrow the focus of what I want to talk about here, and direct it to that part of the pendente lite order of the Supreme Court, which directed that my client, the plaintiff appellant, give over to the respondent 3 days a week of the operation of my client's ongoing individual business.
Just so that we can be clear, at this point, as per the last order and as per, I think, the implicit agreement of the parties, we're talking about 2 days, correct?
I'm sorry.
I'm sorry, because I should be closer to the mic. We're talking about 2 days, right? Everybody kind of agrees right now, as per the last order, it's 2 days?
Actually, no. We had also made a motion to renew, which is part of the record, and the judge decided the motion to renew on May 18th of 2022. That appears in the record at page...
That's the one where she dropped a footnote, and she said, the parties seem to have agreed to 2 days, it's 2 days. And you said, gee, it's 2 days, and the other side didn't respond and say, no, it's 3 days. But I think more to the point, your argument is that she shouldn't have done it at all. Whether
Exactly.
2 days or 3 days, doesn't matter, she shouldn't have done it.
Exactly. So regardless of the amount of days, because it has bounced between 3 and 2 during the
Can I
proceedings.
just ask you, before you go on with that, are you saying that you're asking us to consider a decision that was made in May of 2022 in our consideration of appeals from September and October of 2021 and February of 2022?
Yes, there is a notice of appeal, and that is part of the...
But it's not part of this appeal.
I believe it is.
We were 3.
I'm looking at the
That's February 2020.
cover page, and it references 3 appellate division numbers.
Right, and the third one is from February of 2022, not May of 2022.
The third one is from...
You said May of 2022, and I just want to make sure that you're
sorry,
not talking about some other order.
If I misstated the date, then I apologize.
I want to make sure we're right.
I'm sorry, yes, that is February, and I
But there are
misstated the
the
date.
3 orders, right.
I apologize for that. But in any case, whether it was 3 days or 2 days, our position is that the court below lacked the authority to effectively engage in some form of equitable distribution of an ongoing business as a pendente lite matter. The record is very clear that the photography business was a business that my client had established in 2005 and 2006, well in advance of the 2013 marriage between the parties.
His wife also worked in that business, right?
It's a little bit
But
hard.
his wife also worked in that business, correct?
His wife did work in that business, and there was dispute as to how much time she had spent in the business. My client had
But you
indicated...
don't dispute that she worked there sometimes?
She worked there sometimes. There does appear to be some evidence to that effect. However, what's going on now, to the extent that a pendente lite order is meant to maintain the status quo, what's going on now is that the respondent is operating her own competing business out of my client's pre-existing business. That was never the status quo. So the court below has created
Counsel, in a
its own new
business like
reality.
this, in a business like this, if she has the use of it for 2 days a week, he can presumably use it for 5 days a week. So why can't he continue to do his business?
Well, my client had historically been working out of that business 7 days a week, and part of part of why his customers liked him is that he was available round the clock and had a very quick turnaround time. But his clients can no longer rely on him to be there day to day to day. So if people come in to get their photographs taken and he can get it back to them in a day or two, now he can't guarantee that, and he is in danger of losing business and in fact is losing business. And whether the court was giving to the respondent 2 days or 3 days or 1 day or however many days, it's a day that my client can't run his business. And there's a double counting issue there under the Grunfeld case, which I referred to. And the issue is that the court imposed upon my—
This isn't a Grunfeld issue. Grunfeld is a valuation case.
Well,
this isn't about valuation.
Well,
you know, and in fact, I think what the court was trying to do, whether rightly or wrongly, is that she had a stream of income herself that was derived, and it was on her tax returns, derived from the fact that she worked in this business, right?
She had a small stream of income that was derived from her work.
Well, doesn't that figure into support issues?
That could have figured into the support issues, but that doesn't—
But it did, actually. Not could have, did.
But that doesn't give the court below the authority to grant her access to my client's business so that she can use the facilities and the space and the equipment to start her own competing business.
Even if it was just maintaining a status quo?
That's not a status quo. That was the circumstances that the court below put in place was never the status quo prior to the marriage, during the marriage, and through the case until the court
But you
had
concede
imposed
that she worked there sometimes. So if she worked, I think the court was doing its best to maintain the status quo by saying, okay, let her have it 2 days a week. He can still be there 5 days a week. His employees can be there while she's there. It's a fairly minimal intrusion, especially in these days of remote work of all kinds.
When she worked there sometimes, she was working in the advancement of the ongoing business. Now what's going on is that she's working in the advancement of her own directly competing business, which was never the circumstances that existed prior to or during the marriage, and only existed once the judge imposed that.
This seems to me a classic example of where the solution to a pendente lite order that you're not happy about is to have a rapid trial. Nobody seems to be moving in that direction,
If I can respond to that point, this court has addressed that kind of issue. And although it is a broad and general rule that the response to a pendente lite order that you don't like is to have a speedy trial, that, if you look at the cases, they seem to be reserved to cases where the pendente lite order involves a payment of money. And the reason for that is because the court, when it finally gets to trial, if the court realizes that there's been an underpayment or an overpayment, they can adjust that at the time of trial through the equitable distribution. There's a case on that that three members of this panel have.
Well, why can't this also? I mean, if in fact you're right, that what she's doing is she's pilfering your client's business, and I have no idea whether that's correct or not. If that's proven at trial, can't the court in equitable distribution make some kind of equitable financial adjustment on account of that in terms of the distribution of assets?
Well, the reason I think the court can't do that is because what's happening is the business itself, the character of the business itself is being changed from a business that runs 7 days a week to a business that runs either 4 or 5 days a week.
And that would change the value of the business. That's what it does.
Well, it can also change the character of the business, and yes, it can change the value of the business.
Well, which reflects the value of the business, if the character, you know, so I'm not sure, you know, that your rationale as to why a speedy trial wouldn't be the remedy holds. I think that this can be financially adjusted for. It can be.
Well,
if it's wrong, it may not be a wrong decision, I don't know.
But what the court did was, the court imposed upon my client an obligation to pay spousal maintenance to the defendant respondent based on an income that was based on him operating the business at full speed. And when the court effectively, if Your Honor is correct, that it reduces the value of the business, the court reduced my client's income-producing capacity without reflecting that in the amount of support he...
Possibly. Again, that would be figured out in the ultimate numbers after trial.
Well, I
mean, you know, pendente lites are Band-Aids to get everybody through. and sometimes they're more perfect than others.
There's a case called Gadd v. Gadd, 283 AD 2nd, 200, out of this court. It's a 2001 case, and it talks about an exception to that, a very strong exception to that rule about the best remedy to a pendente lite order that you don't like is a speedy trial, and it makes an exception where, I'm sorry, you know what, I'm citing to the wrong case.
No, it's all right. I'm going to accept the proposition that while it's the general rule, it's not a hard and fast.
But an important case, the one that I meant to alert the court to, there's a case called Levin versus Levin. It's a 2022 case, slip opinion 3050, and 3 members of this panel were on that case. And it says that although the general rule is that a pendente lite order should be challenged by way of a speedy trial, there's an exception to that when the pendente lite order involved a double shelter, an impermissible double shelter allowance. Now, a double shelter allowance is not exactly the same as the double counting issue in Grunfeld, but it's quite analogous. It's the idea that when you consider the value of one thing but don't adjust for it in terms of the payment, that's not just an improvident exercise of the court's calculations of the pendente lite support order. That's something where this court can step in. So I would submit that the Levin case is really the answer to the court's question of why the speedy trial rule should not allow the underlying orders to escape appellate review.
Okay, thank you.
Thank you.
Good afternoon. If it pleases the court, my name is Amy Saltzman. I represent the defendant respondent wife in this case. As far as the business and all the claims, in the record, it is clear that my client helped develop this business.
Counsel, I'd like to ask you about the maintenance part of the award.
Oh.
It appears to me, I mean, the other part's interesting as well, but in terms of the maintenance amount, it appears to me that the trial judge gave your client maintenance based on the statutory guidelines and also ordered plaintiff to pay rent and other housing costs. It seems to me that by adding, since those are supposed to be included in the statutory amounts, that that's really a deviation. And when a trial judge does a deviation, whether it's pendente lite or in the final analysis, there has to be an explanation of that deviation. I didn't see an explanation of that deviation in the trial judge's decision. In the absence of an explanation for that deviation, don't we have to reverse that part of the award?
I think...
And actually, it sounds like 1111 is a good example of that, but isn't there a deviation that was not explained?
Well, I don't know. The judge continually said that he should continue paying certain expenses. He started...
Well, but that's which I would interpret as, if he failed to do that, you would have gone running in and saying he's violating the order, right?
Well, yes, or seek another adjustment of maintenance.
Yes, you understood that to be an order that he continue to make those payments and also pay the amount set by the statutory guidelines.
Yes, again, she says it over and over again. The other thing she says continually...
Why isn't that a deviation?
Why isn't it a deviation? She very carefully talks about how she set this award, and she says it in different ways. She says it that she doesn't believe his income. She talks about payments for personal and family expenses coming from the business itself, saying that the expenses that he puts in his net worth statement is way above what somebody...
Let me just stop you for a minute, because that would justify the imputation part of the award. But then once the money was imputed, was she bound to otherwise follow the temporary maintenance formula to come up with the presumptive amount, and then if she deviated from that, explain? I mean, was the process appropriately followed? You're talking about imputation of income.
Right.
And she does seem to provide some basis for why she did that.
Yes. I read it as explaining her deviation. She doesn't say that word, though, Your Honor. You're correct. She doesn't use that I scoured the decisions. She just continually talks about how the amount that everybody puts as expenses doesn't meet the claimed income, earned income from the business. She notes that the profit from the business was over $375,000 in the year that he claimed $50,000 in income. And that's the way she justifies, I think, the awards. She also, this is a motion to renew, and what he put for the renewal of the maintenance and child support was the fact that he has 50-50 parenting time, which does not warrant modification of an award, and then claims that he has his 2020 and 2021 tax returns, which she then goes on to say how that doesn't change anything either and supports her imputation of income. And so that's how she's talking about it. And I don't know, she did it 3 times, actually, in this case, because there was an in-between amended interim order where she increased the amount of the maintenance while she decreased the amount of time my client could spend in the studio. This is a photography studio. And the other point that counsel didn't object to at all in the motion practice was the fact that the husband has employees working in this studio 7 days a week. Even when my client is there, there are his employees running the business. He also claims he has 50-50 parenting time, so I'm not sure how he gets to work in the business 7 days a week now either. He showed no decrease in his income or any financial information indicating that the wife's presence in the studio a couple days a week impacted his income from the business as well. And so therefore, I think
Can I ask you one question, too?
Yes.
There was some information that the wife is competing with the husband. Was any of that put before the trial judge?
Not at all. No. And there's no way she's trying. He cut her off from all of the electronic access to the business. He cut off her access to clients. He cut off her access to the Dropbox. He did her in. I mean, and this was right after he assaulted her, and then there was an order of protection. He banned her from that business and gave her whatever he wanted to give her, which was paying the rent and giving a little bit of money to let her survive until the divorce started, and then we got the pendente lite order. And therefore, that was the scenario, and still now, to this day. I mean, whatever is on the tax returns as to her income, that's what he paid her. It wasn't exactly that she had control over the money coming into the business ever. And that's the scenario, and she's trying to rehabilitate herself as a photographer. There is in the record on page 855 where the husband says, "You helped me develop this business." I mean, he says it, and there's another place where she's on the website. She's the founder of the business. To this day, he claims it's separate property, but there's been no finding of any of that. We're up to trial, and that's the best remedy to pendente lite inequities, I would say, is a speedy trial. Thank you, Your Honors.
Thank you. Rebuttal, counsel?
I would like to respond to a couple of items raised by my adversary. In terms of the idea that there's been no finding of fact as to this being a separate property rather than a marital property, if the court looks at the record at page 10, that's the first of the decisions, the September 1st decision, the court specifically says that it's uncontested that my client, the appellant, started the business prior to the marriage.
That's not a finding of fact. That's a final finding of fact. It's at the time of the pendente lite award.
But where my client says that he founded the business and started the business and formed the LLC in 2005 and 2006, and the marriage wasn't until 2013, in response to any of that, the respondent in the motion practice only said that he saw me as a partner, I behaved as a partner, we built the business up together, and that may well be true, but that doesn't make it a marital property. What that means is that if she contributed
not necessarily. I mean, if the appreciation on the value.
Absolutely. If she contributed to the growth of the business.
That's why that's why there has to be a trial. Evaluation from the date
But there's something different that's going on here, because if, to the extent that she claims that she contributed to the growth of the individual business, she'll be entitled to a financial compensation for her to the extent that her labors contributed to the growth of the business. But she'll never be entitled to a share of the business. She'll never be entitled to work there 3 days a week and 4 days a week. Ultimately, my client will own the business, and he may have to pay her for her equitable contribution to the growth of the business.
I'll grant you that that is a very typical outcome, but it's not the only scenario after equitable distribution. Typical, but not a foregone conclusion.
Well, I would submit that in a case where it's an individual business that was clearly before the marriage, her only relief will be in the form of money, not in the form of sharing the business.
Or maybe it'll be in money to him. I'm just saying it's not a foregone conclusion. It's a very likely scenario, but not necessarily the scenario, right? Well, you don't agree, which is okay. It's okay.
I suppose we'll find out. I don't think so.
It's okay.
What I will say is that also, in response to the idea that there's no evidence that the respondent is operating a competing business out of my client's ongoing business facility, there's only 3 possibilities. Either she's still working for him, which is not the case.
Which is not the case. Everybody agrees.
Or she's doing nothing, which is not the case.
Right.
Or she's working for herself.
Well, that doesn't mean that she's necessarily in direct competition with
Well,
him.
if she's running,
you need a trial, right? I mean,
if she's running a photography business out of a different photography business,
but it doesn't mean that those would all wind up his clients. How do we know?
it may not be. But
Right.
that's sort of like saying McDonald's doesn't compete against Burger King because not everybody who doesn't like McDonald's goes to Burger King. But
Was there any, but
I'm sorry.
Ms. Saltzman said there was no evidence before the trial court that she was competing directly. Do you acknowledge that there was no evidence, do you agree that there was no evidence before the motion court by your client to show that she was competing directly with him?
I disagree with that, because in the motion to renew, there was evidence that she was advertising in certain ways on her own internet advertising, and my client, I believe in the motion to renew, made reference that at least there was the danger that she would be taking his client.
A danger is a difference from an actual competition. There's no evidence in the record that she was stealing his clients or anything like that, correct?
She was advertising to the same clients, and I would submit that my adversary...
What does mean?
I don't know what that means.
Putting a web page out, you reach the entire whoever can access. And that can't be his whole book of business.
Well, what I would submit is that part of it should be taken, and you could take my adversary at her word, which is that she's claiming that my client cut her client off from the client list. So if she wants the client list, then clearly she's at least looking to compete, and there's no reason for that to be going on a pendente lite basis.
She doesn't have it now. She's not competing now. All right. I think we understand your arguments. Thank you. Thank you both.
Thank you. Thank you for your time.
$3710 114th Street versus Chen. You may proceed.
May it please the court, Austin Grant from the Shell Law Firm for the defendant's appellants. The issue in this case is very simple. Did the plaintiff establish that there was no genuine issues of material fact, that a debt remains due and owing between the plaintiff and the primary debtor, such that the guarantee executed by the defendants was triggered? The defendants say no, and therefore the motion for summary judgment on the issue of damages was erroneously granted, and this court should now reverse and remand the matter for trial on damages to the extent there remains any due and owing to the plaintiff. The plaintiff seized the membership interest in limited liability company Chattis Mez DE LLC.
Yeah, I think we're familiar, and I'm just going to sort of speed this up a little bit because we only gave you a little bit of time. So the real issue is that on the guarantee, there was pretty direct language about no set-offs, no defenses, no, nothing, you know, if the debt isn't paid, you owe the debt, thank you very much. So why should there be any issues of fact that pertain to whatever happened to the collateral in the underlying case, which in the underlying foreclosure, which I think is your client's biggest gripe here, that the foreclosure will result in a judgment or money coming back to them or their entity in a different way, and why shouldn't this be determined holistically?
The issue here is whether or not there were damages. If the primary debtor gave $8.4 million to the plaintiff in this case, there'd be $100,000 owed, and the guarantee would be triggered. Understood, but we're not asking for a set-off. We're just asking how much money does the plaintiff have in its possession or assets valued in its possession to that there remains damages such that there's a guarantee triggered. In paragraph 5 of the guarantee, it discusses that they can, the guarantor, that the lender may enforce the obligations of guarantor under the guarantee by a proceeding at law, in equity, or otherwise independent of any loan foreclosure, UCC sale or similar proceeding, or any deficiency action against borrower. The language itself says you must take the asset that you take from the borrower, and if there's a deficiency, you can either go after the borrower or the guarantor. You don't have to wait for one or the other, but there requires a deficiency. We don't know if there's a deficiency here. That's section A of paragraph 5.
So in the UCC sale, there was $500,000, right? And how much is your loan?
It was a $6 million.
And how much was did the collateral get sold for? $500,000, right?
It sold for $500,000.
So $6 million plus default interest minus the collateral makes a lot of money, right?
Agreed, except that under the UCC, when you determine the value of the asset taken by the borrower.
That has nothing to do with your contractual obligations. You've contracted away some things that you might have had, and you said, I will pay you regardless of anything else that happens. Once the loan goes into default, I owe you the cash. I'm not going to be able to offset. I'm not going to be able to claim any counterclaims. Whatever I've got to do it in another litigation. That's a pretty standard guarantee, and that's what you said. Do we not agree with that?
I agree, except the court below did not take into consideration the $500,000. So that was an error on the calculations. It was not taken into consideration. So the lower court never addressed the $500,000 at all.
Okay.
So even if the court were to subtract the $500,000, the lower court erred.
All right, let's hear from your adversary.
Thank you, Your Honors.
Thank you.
May it please the court, I'm Norman Flitt. This is a very explicit and clear guarantee.
No, let me just ask you, what about the $500,000?
That is a credit bid, and the question is when that should be applied to benefit the guarantors. Under the terms of paragraph 5J of this guarantee, they'll have to wait for that application until the judgment is paid in full. That's the way it reads. No offsets, no credits. Pay us first. That's very clear. And then they have their claims pending in Supreme Court, Queens County, for, among other things, a surplus. The guarantors joined as plaintiffs with the borrower.
Yeah, so that's my question. Why is this all not in wherever
why isn't it in
Queens? Right, in Queens, where the hotel is. Why are we litigating two different things? Not that I'm saying that you can't get your judgment, but I mean, that judge has a sense of this case. Why not just litigate it all in one place?
Because there's a specific venue provision in the pledge agreement here that's controlling. It says Supreme Court, New York County, file suit in New York County, which is what we did. And that's what we have the right to do because the guarantee is independent, it's separate, the guarantor's obligations are broader, and we followed the documents, which is what this court should do. Follow the documents. And in terms of the cross appeal, if you follow the documents, the judgment has to be adjusted upward to account for the per diem default interest. We only got standard. I have the figures in my brief. It's approximately $244,600 more. So the principal amount, if anything, of this judgment should be increased. And if, as and when, the whole thing is determined, I mean, there's a $24 million first mortgage in foreclosure in federal court. There are these 4 other actions in state Supreme Court on encumbrances to the property. So don't talk to me about the membership interest having any at present value. We're in a quagmire as to what we did. We're entitled to our money, and we should get paid now, and that judgment should not be reduced. In fact, it should be enhanced by the default interest.
Just one
What should
question.
the default interest be?
How much would it be?
Yes. I mean, how would you calculate, in your view, how should the interest be calculated?
Well, you should follow the documents. In terms of what's in the record, there's Exhibit F. I think it's 248 page of the record. There was a per diem rate for the, it was $3,400 and change per day. And we put that in the papers. Further, there were definitions of what the default rate is. It's 10% above the regular rate, which was 13.6. So the default rate together, according to the documents, is 23.6. The per diem number is there, subject to computation. I put the numbers in the conclusion of both my briefs.
So, and just staying on the interest rate for a moment, the limitation, the contractual limitation and legal limitation on the interest rate was that it had to be an otherwise legally permissible rate. It would be the lower of. And is it your understanding that that legally permissible rate is anything up to the usurious rate?
Oh, no. I think so long as it's below 25%, if there's any usury prohibitions. The other rate was based on LIBOR. It was computed at 13.6, and then it's 10% over that. 23% is
it's a
standard default interest rate.
It's a legal rate, is what I'm saying. Legal. It's not otherwise prohibited.
Oh, no, no. Oh, no, no.
Yes, that's what, I know my question was convoluted, but that's all.
No, it wasn't. My answer might have been. Okay, if there are no more questions, I'm done here.
Okay.
Thank you.
All right, we're not arguing with that. Okay, let's hear from your adversary.
Thank you, Your Honors. I just want to cite to Chemical Bank versus Alco Gems Corp., where this court looked at the creditor bank, the creditor took the gems, and the court held that the court remanded the case to determine the amount owing to Chemical Bank and the fair market value of the collateral seized, which should be deducted from the debt if Chemical elects to retain it. The plaintiff here has elected to retain the property and the membership interests. There should be, there has to be established that it's owed money in a 3213 motion for summary judgment. I understand you're saying—
That is not correct. That's not what you contractually agreed to. That's the problem. You didn't say, let's figure out what I owe you after we decide whether or not the sale was commercially reasonable, after we deduct any money that you got from the sale, after we have a litigation somewhere else. You said, once there's a default, I owe it. No offset, no nothing. I pay whatever the default was. And that's what the contract says, correct?
It does, except if the borrower had paid $8.5 million, the plaintiff could not proceed against my client. That wouldn't be
But that's the whole point, is that, but that's why you're a guarantor, right? That's the whole point of getting the guarantee. So we don't worry about what the borrower is doing. But let me just ask you, you didn't dispute that the interest rate you didn't, in your brief at least, you didn't say anything about, you know the interest rate is not 9%. It's what the document says.
Whatever the document says the document is. I'm not disputing that argument.
Okay.
Thank you, Your Honors.
All right, any further rebuttal? I don't think so, Your Honor. Okay, thank you. Thank you both. Schwartz v. Genfit.
Good afternoon, Your Honors. Michael Warnke on behalf of the plaintiff appellant. I think it's important to state at the outset what this is a Section 11 claim under the Securities Act. I think it's important at the outset to state plaintiff's claims are not premised on a simple disagreement over a statistical methodology or a post hoc analysis done by Genfit. It is not simply about that there exists inherent flaws in a post hoc analysis, or it is not based on an affirmative claim duty to disclose all details of any analysis that is done. Rather, plaintiff's claims are based on affirmative misrepresentations and misleading statements placed in the registration statement that defendants chose to place in the registration statement, and that that was specifically addressed the results, how the results were obtained, why the post hoc analysis was done, and the purported reliability and strength of those results. The misrepresentations fall under three general categories. First, they misrepresented how and why the post hoc analyses were conducted. Second, they misled investors as to the strength and reliability of the reported results. And third, they misled investors about the difficulties that the Phase 3 trial was experiencing that impacted the enrollment, the retention, and the results.
And that is sort of the elephant in the room, the data dredging issue, right? Data dredging, the data mining that kind of weaves its way into all these points you're making. Is that it?
Yes and no, Your Honor. The data dredging is the underlying issue here, is about what Genfit did. As the head of regulatory affairs for the entire company and quality, at the time the registration statement was issued, at the time these false statements were made, stated that what was really done is that after the Phase 2 trial failed, Genfit management went to their biostatisticians and those in regulatory affairs and said, here, reprocess the data and, quote, make it look better. Now, when they did their registration statement, they didn't have to provide any types of details of what type of post hoc analysis they did or the details or why they did, but they chose to put it in there because they were trying to raise funding for their continued operations.
Right. In fact, the trial that had taken place where they did an analysis, not post hoc, was not promising. It wasn't going to get investors to otherwise support this product. So your complaint, at least, claims that they went back after the results of the Phase 2 clinical trial was done, and that they looked for data according to different criteria and characterized it.
Yes, and I'm going to clarify it, that what they did is they didn't simply say, okay, well, let's consider these three things, and then now let's go look at it, let's open up the data and see what the results are, right? That's still a post hoc analysis, and as CW1, the head of regulatory affairs, says, is there's times where post hoc analyses can be useful. There's always flaws and problems with post hoc analyses, but they can still be useful. But that's not what Genfit did here. What they didn't say, oh, what about these 3 types or 4 types of situations? Let's open up the data and look. They opened up the data, reprocessed, looked through everything, looking for any type of subset data.
No, but okay, but what is the specific statement that you are saying that they stated about that is false or misleading?
Yes, Your Honor. So there are the statements up here, I think on the record, it's on pages 281 and 282 in the registration statement. And what they say is, they first say, we conducted a post hoc analysis. And what we did is, the prior definition used in the original Phase 2 study had used a quote-unquote outdated definition of NASH resolution. And what we did is we used the FDA recommended definition.
So let me stop you there, because that wasn't false. That was part of the post hoc analysis, wasn't it?
No, Your Honor. They're stating that what they did is what they're stating is
They changed criteria by redefining the disease, right?
Your Honor, what we're saying is that they did not identify that the definition was outdated, right? Defendants make that claim, right? But that definition, as we state in the complaint, that definition never existed. There was no FDA recommended definition that was out there on a FDA website. The first time
You're saying that was a false representation, that the definition that they used was an FDA definition? Is that it?
Your Honor, I believe it's paragraph 91 of the complaint. We state that the first time anyone ever heard of this definition was when GenFit announced that they were going to be using this definition. There wasn't anything, I believe even analysts commented.
You mean in the prospectus?
No, this is because even before the prospectus, GenFit was doing private placement fundraising based on the phase
And there was a peer-reviewed article, medical reviewed article, where they talked about the post hoc analysis, and they specifically mentioned using the FDA definition, recasting the criteria.
Your Honor, the whole point, though, is CW1, the head of regulatory affairs, said what they did is they went and they opened it up and reprocessed all the data.
I get that, but I'm just trying to understand what the investors saw and what was misleading about it.
Sure.
And correct me if I'm wrong, but the registration document made reference back to this 2016 article, right?
Yes, Your Honor.
And that article contained a lot of information, not only about the phase 2 clinical study, but the post hoc analysis that was done by the corporation, correct?
Right, Your Honor. However, but the basis of that, though, in Section 11, essentially what defendants are claiming is what's referred to as truth on the market defense, saying, sure, maybe the statements in the registration statement were misleading or false, but there was other information available to investors on an efficient market, and therefore they weren't misled.
I'm saying something different, actually, because as I read the briefs, and maybe I'm wrong, that the registration statement incorporated and referenced that article specifically, so that it was really part of it. It wasn't just go look out in the general marketplace, although it is available in the general biosphere of information.
Well, I got two responses to that. One, my understanding is under Section 11, they're not allowed to incorporate other things outside that's just in the public interest, right? That's the whole point of Section 11. That's why Section 11 is such strict liability, is it goes from buyer beware to full disclosure. The courts have been very clear that an investor is not required to look anywhere beyond the prospectus for any of the information. If there's a false statement in there, now you have a Section 11 claim. Under the point of it being the article in the gastronomology or the journal being available to the market, that is an issue, a factual dispute. This was in a specialized journal, and it's not clear that at the time it was published that it was available to the general public.
But wait, again, I'm just trying to figure it out. Are you saying that there was no FDA-approved standard?
Yeah,
that was just completely made up?
What we're saying is that under this one piece of it, what we're saying is that the basis of them conducting the post-hoc...
No, I'm not talking. I'm saying they said to the public, we did this post-hoc analysis using this new FDA-approved, I don't know, schematic. And you're saying that there is no, is that what you're saying? There is no FDA?
Yes, at that point in time, and maybe even as to today, there was not an FDA-recommended definition of Nash resolution. That was not something that was there.
So that's a fraud. That was false.
Or false.
It was false. With Section 11, we don't need to prove scienter and fraud.
Understand.
Simply, it could be a misstatement, a negligence drafting of the Section 11. But I believe in paragraph 91 is where we address the fact that even analysts commented, this is during the funding of it when they're going around telling everyone it's unequivocal evidence of supporting efficacy, they commented about that. The other issue, though, I do want to state, because it gets away from the FDA definition, is the other one, also on, I believe it's on 281 of the record of the registration statement. Again, they say that the original study it contained patients that had, quote, too low a mass, which is the level of your condition, right? That implies that the original study and the phase 2 study, incorrectly included people that shouldn't have been included, and that they were, in essence, that they're correcting that error, right? But that wasn't the case, again, as CW1 had stated, that they had just reprocessed it, found subsets, and then, and essentially, the implication is that they came up with excuses or reasons after the fact, saying, well, okay, this, we found out that this group had has a statistically significant response. So I guess the idea is that everyone that wasn't included in this group then was somehow wrong to be included. It's the tail wagging the dog, Your Honor. Yes?
I have one question on a slightly different point, which is this. It seems to me that your case is largely about the confidential witnesses, but it seems to me that the significance of the confidential witnesses is that they're not random employees, but employees who have specific expertise. And so what I'm trying to understand is your claim as to them that the company made statements which were contrary to the opinions of its own internal experts, and is that something it had a duty to disclose?
Yeah, that's exactly right. That gets to the second category of alleged misstatements. And this second category completely takes our case away from cases like Kleinman and the others that defendants rely on. Because defendants didn't simply say, we did a post hoc analysis, here are the results, that's it. We already discussed the fact that they said, oh, we did it to correct errors and things like that. But more so, they said, moreover, that we believe this is a good assessment of the efficacy of the drug. They didn't have to say that. They chose to say that. And the Supreme Court has been crystal clear in Omnicare that if you're going to go out there and tell people, we believe, such and such conduct is legal, or in this case, such and such evidence, demonstrates the efficacy of the drug, then it's reasonable for investors. Investors expect that, one, you spoke to your experts, and two, your experts agree with you. It has to reasonably align with the information at your disposal. But here, the CW's made clear that all the people in regulatory affairs, all the biostatisticians that did this, disagreed with it. They said that it was, that it was doomed to fail, that I forget the exact language that they said, but that it was, they're severely doubtful or very doubtful. They knew that the phase 3 wasn't going to work.
So let me ask you again, counsel.
The CEO wasn't listening, sorry.
So you're saying the one falsity was that why they did the post hoc, not that they did it, the reason why it was done. And the second, are you saying, is why they chose to go to the phase 3?
So number one is why they chose to do the post hoc analysis.
Right.
And then related to that,
and number 2 is why they decided to go to the phase 3 study?
No. Number 2 is that they said that the results demonstrate a good assessment of the efficacy of the drug.
And did you make any allegations as to why they went to the phase 3?
Yes, that's in sort of the second group of false statements that kind of get with in the same one about the efficacy. They also go on to say that they're well positioned for FDA approval. I'm paraphrasing. They said they're a well positioned phrase compared to other drugs. And then they also said, based on the results of this post hoc analysis, we're moving to phase 3. But the confidential witnesses again stated that no company would have ever gone to phase 3 based on these post hoc analyses results, but that the CEO and management was not listening to the experts because they were more interested in getting the funding out of the IPO than putting a drug on the market.
All right, let's hear from your adversary. You can proceed.
May it please the Court, Sarah Lightdale from Cooley on behalf of the respondents. Your Honors, the registration statement could not have been clearer that GenFit conducted the post hoc analysis because its phase 2B trial failed.
Well,
it failed. Yes, Your
Did they
Honor.
ever disclose that their internal experts were in disagreement about about the effectiveness of the post hoc analysis and the implications of it for going on to phase 3?
Your Honor, that allegation or that proposition rests on a mischaracterization of the record. But let's assume, for the sake of this argument, that there were some employees within GenFit who did not agree with conducting a post hoc analysis, who did not agree with the decision to move on to phase 3. That is not required to be disclosed under the securities laws. The Supreme Court in the Omnicare
What
opinion—
about if the chief scientist in the company had said, this is not a good idea, this does not show that the drug is effective? They wouldn't be required to disclose that?
Oh, certainly, Your Honor, but that's absolutely not the allegation here. So in Omnicare, the analogy that the Supreme Court uses is, let's say that there's a statement of opinion regarding legal compliance. And let's say that there is a junior attorney who disagrees with that. And let's say that there are 6 senior attorneys who put their stamp of approval.
No. We've read Omnicare. We don't need you to tell us about Omnicare. What I want to know is why, if the plaintiff has alleged that the opinion that you gave did not fairly align, as Omnicare says, with the information that you had, then it's actionable. So the question is, the plaintiff alleges you had information that didn't align with your opinion that the post hoc analysis provides a good assessment of the efficacy of the drug.
Your Honor, to the extent that what plaintiff is saying is that the information that we had is that some employee somewhere within the organization disagreed, and that's actually not alleged. To the extent that's the allegation, that is not required to be disclosed under the federal securities laws. Let's talk about the Kleinman case, which directly forecloses, from the Second Circuit, which directly forecloses the argument here. In Kleinman, very similarly,
I'm going to stop you for a minute. Would you have to disclose, though, if you did a post hoc analysis, and let's say you ran 5 different tests, and one of them was very favorable to your position, and you put that in the registration statement, would you be required to otherwise disclose that you conducted other post hoc analysis that was not favorable to a conclusion that this was an efficacious drug or had potential to be a drug that was approved by the FDA?
No, Your Honor, you would not be. So under the Carrick's case from the Southern District of New York, the court directly said there is no deep dive disclosure requirement that an issuer disclose every single piece of its methodology, every analytical choice that it made. And that would be unworkable. Your Honors, this is the registration statement already. If an issuer were required to disclose every scientific opinion, every view of everybody at the company, go around, take a poll of all the junior people, how would science ever move forward? How would companies ever—
So, but wait, here's the allegation. I mean, we don't know if this is a pre-answer motion to dismiss, right? The allegation is that the information in your possession is that that study, that ad hoc study, was inconclusive or showed that it was doubtful. And I mean, frankly, the drug failed, right? But you went on your prospectus and said that we think that post hoc analysis provides a good assessment. In other words, that this post hoc analysis shows that this drug is going to work. And in fact, the allegation is, maybe not true, maybe who knows, but that at that time you had the information that you had is that it wasn't. It was doubtful or inconclusive at best. So that is my point. That is definitely actionable under Section 11.
I understand, Your Honor. I understand your question. So the allegation that we had conducted analyses that we did not disclose is flatly foreclosed by the documentary evidence.
I'm not talking about that you didn't disclose. I'm talking about that you had information that shows that the statement that you made was not correct.
Your Honor, under Omnicare, the only omission that will render an opinion statement misleading, and again, this plaintiff has disclaimed fraud, and so he cannot proceed on dishonestly held opinion theory, so he must proceed under the 3rd prong of Omnicare, which is, I think, what you're getting at, which is that it's not just any fact cutting the other way that exposes, because clinical trials are endless amounts of data, endless scientific judgments. It's not any fact cutting the other way. It's got to be a fact that directly goes to the inquiry that was conducted.
So that is what the plaintiff alleges, that at the time that you were saying that post hoc analysis provided us with a good assessment that this drug is going to work, that the information in your possession was exactly the opposite, that it was doubtful that this drug was going to work, and that it was at best inconclusive. So again, I have to assume that those allegations are true. That states a claim under Omnicare that the information that you have doesn't fairly align with what you are telling the purchasers of the security.
Your Honor, those are conclusory allegations, and the court is not required to credit them. The only facts that are in the documentary record and the only facts that are alleged in the complaint are that GenFit conducted a post hoc analysis to take into account an FDA-recommended definition of NASH resolution. This is a nasty disease, which is a fatty liver disease, which is increasing with the obesity epidemic. The trial, phase 2B, started in 2012, and it finished in 2015, and medicine moved in that time period, and the FDA updated its recommendation. Despite what you heard from my adversary, that is actually not alleged to be false in the complaint. You will not find in the complaint an allegation that the FDA did not recommend that they update that definition. So, GenFit disclosed, we used a new NASH definition, which the FDA recommended. We also took into account baseline severity, how sick the patients were. We also took into account standard of care across treatment centers. And they disclosed in detail all of the different statistical analyses. This is how plaintiff was able to allege it, because GenFit disclosed it. They walked investors through. Here was our methodology. Here is how we got to our conclusion. And, Your Honors, the registration statement has 50 pages of risk factors. 50 pages. They are very specific. They specifically say, we cannot give you any assurance that this trial will succeed, that that phase 3 will succeed, that the FDA will agree with the way that we proceeded to phase 3. Investors who invested in GenFit were told on the front page of the registration statement, this is a highly risky investment. Proceeding to phase 3 on the basis of a phase 2B post hoc analysis was an extraordinary gamble, and investors understood that. Now, could there have been an extraordinary payoff? As I say, this is a disease with significant unmet need. There is no approved treatment for it.
That's what the plaintiff is arguing. The allegations are, you're hitting about risk. Investors, they look at the risk, they assess risk. And the sense I got from the record here is that what you put in your statements and your IPOs allow them to assess the risk that they were going in. And his argument is like, you didn't really go all the way. And yes, you kind of skewed our risk assessment. And if you had done what my colleague was pointing out, that may have changed their risk analysis for them, whether or not to put in money or not. I mean, it's all risk. No, you could lose your shirt, but it depends on how much. Is it 10% risk? Is it 50% risk? And they're saying, yeah, you know what? The statements here, it was really a 99% risk that we were going to lose our shirt, but the way you portrayed it, it looked like it was only 10%.
So, Justice Owen, I'd like to directly address the data dredging point that you noted is sort of floating around. So the allegation—
The elephant in the room.
It's the elephant in the room. There we go. The allegation, a few points. Number one, as alleged, the anonymous person who that allegation comes from was not at GenFit when the post hoc analysis was conducted. Post hoc analysis is 2015. The IPO is in 2019. As alleged, that person, I think we've been referring to them rather loosely as an expert, doesn't work in drug development at all, is not a biostatistician. As alleged, that person was just repeating something that they heard from somebody else years after the fact. Number two, even that anonymous person does not say that GenFit engaged in data dredging. That is plaintiff's nefarious, our own pejorative characterization of a post hoc analysis. But what the Second Circuit said in Kleinman is that investors knew what they needed to know when they understood that a company proceeded to phase 3 on the basis of a phase 2B, that a phase 2 did not meet its endpoint.
So you're saying that this whole argument that, we were totally caught off guard, that an investor would know, who is in this kind of industry, would know No, you had to know. There's no way you wouldn't have known what's going on.
Absolutely, absolutely, Your Honor. What the Second Circuit said in Kleinman is reasonable investors know that post hoc analysis is inherently less valuable. The allegation in the complaint is it's inherently statistically flawed, that it violates, that what GenFit did violates the statistical rules. That is a scientific disagreement. That is not the stuff of the federal securities laws. And if it were, to be the standard, then the courts would be deluged. There would be a floodgate of every time a clinical trial fails, somebody disagreeing with the benefit of perfect 20/20 hindsight, which is quite easy to exercise, Your Honors, of simply saying, well, let me go back and criticize a judgment that was made. And that's why not just Kleinman, but federal court cases like Padness v. Sias Nova, like the Third Circuit in the Edinburgh. Yes.
But there are other cases that say it's not the data, it's not the post hoc analysis, it's the post hoc, it's the misinformation about why you conducted the post hoc. And there are plenty of cases that say that that is actionable, and that's what plaintiff, I think, is alleging here. It's not the fact that you did the post hoc analysis, it's telling the prospective buyers why you did it, which was false. That is what the plaintiff is alleging.
Your Honor, what is alleged is completely consistent with what GenFit disclosed. So this confidential witness one, first of all, what GenFit disclosed is we failed to meet our pre-specified endpoint. We failed to fulfill what we set out to do in the protocol for phase 2B. And they said, then what we did was we looked at the data using several new variables. And that could be risky, there could be differences of scientific opinion on that, but that's what we did. That's what GenFit said. The registration statement could not have been clearer that we conducted the post hoc analysis because, let's talk about the purpose, because the phase 2B study failed. And anyone who—
Well, wait. Didn't you say that we went to phase 3 because in phase 2, there was a resolution of NASH without a worsening of fibrosis? I thought that was what the plaintiff was saying was false.
Your Honor, there is an opinion statement, so of course that puts us back in Omnicare world, that we believe that this analysis, this post hoc analysis, provides a good assessment of the efficacy of elafibranor. Now again, under the CVS Health case, and as we've acknowledged, the plaintiff here has disclaimed fraud, and he did that for a very specific reason. He did that to take advantage of the benefit of a lower pleading standard, which, believe me, none of these confidential witness allegations would prevail under 3016B, and he knows that, which is why he's disclaimed fraud. But so there cannot be an allegation that the company did not, in fact, believe that statement.
Am I gathering from—
No. It's not that you didn't believe it. It's that you had information that showed that it was false.
Correct, Your Honor. And so I understand Your Honor is now talking about the third prong of Omnicare. Right. Sorry, not correct, of course.
I mean, that's all we're talking about.
Understood. And as to the third prong of Omnicare, what the Supreme Court said is you have to—
I know what the Supreme Court said. I just want to know why this is not sufficient.
Yes, because GenFit disclosed the nature of its inquiry in determining to move forward to phase 3. The nature of its inquiry, Your Honor, was post hoc analysis. If you Control F the registration statement, you will find that 100 times. It is over and over and over. GenFit says, we did this, it's risky. Yes.
So going back to Kleinman, when they talked about the post hoc analysis, you're saying that the only way that the plaintiff could get around Kleinman was to come up with this nefarious notion that it was data dredging, because we know that if you were going in and challenging the post hoc analysis, Kleinman would just slam the door on you. And this assertion now is the only way to get around it somehow, right? To just cast doubt on what we did. When this is exactly what we did, but that's the only way to get around Kleinman is to do what they're doing now.
Your Honor, I completely agree with you. I think that Kleinman is entirely on all fours, and the data dredging allegations are really just an effort to get us out of the Kleinman framework. They are not well pled, they fail. What is alleged is consistent with what GenFit disclosed. Further, Your Honor, plaintiff has not distinguished the Carrick's case from the Southern District of New York, which I referenced, which specifically says, in Carrick's the issue was interim analyses. Here it's at the end of the trial analyses. But it's same difference. In Carrick's, the plaintiff said, you ran lots of tests and you didn't tell me what they were. I should have known that so that I could run my own statistical analysis. And Judge Forrest in the Southern District said, investors are not entitled to that kind of deep dive disclosure. Sure, you might find something else interesting. Oh, you might like to know something else, but that doesn't mean that there's a duty to disclose it under the federal securities laws. And there was nothing that GenFit did not, GenFit fulfilled its disclosure obligations. It was not required, it did not say anything misleading that any of the alleged omissions get to. And basically, this ultimately is, again, you can look at the very beginning of the complaint. It's record, I believe, 137.
I'm going to ask you, we've given you a lot of time, so you need to wrap up your argument so we can hear your adversary's rebuttal.
Absolutely, Your Honor. And the
you.
very beginning of the complaint, what the plaintiff says is that the post hoc analysis was fundamentally flawed and it violated the basic tenets of statistical analysis. That is a difference of opinion and judgment regarding quality and reliability. All of the federal cases that we have cited to you, Your Honor, this case would not stand a chance. And Justice Schechter properly dismissed it. She read the registration statement and she read the cases and she dismissed it. It should be affirmed. Thank you.
Thank you. All right, we'll hear some rebuttal.
Thank you, Your Honor. A couple things I'd like to address specifically. Defendants had spoken about the Kleinman case and the Carrick's case. All of those cases, and many of the others, are easily distinguishable from the facts that we have here that are alleged here, including Carrick's. Kleinman, first of all, Kleinman simply had to do with a company that said, we did a post hoc analysis, here are the results, that's it. They didn't take it upon themselves to elaborate about why it was done, how it was done.
Yeah, but if that's the case, assuming that's the facts are in this case, that they're saying that we did the post hoc analysis, this is it, this is how it's going, Kleinman would say, you're out of luck. But you're saying, well, wait a minute, there's this notion of a data dredging that occurred. Isn't that your way of trying to get around Kleinman?
I don't understand, I don't know about getting around Kleinman. It's different than Kleinman because here, one...
That's getting around Kleinman.
Yeah, I believe it's getting around it. I guess when I hear getting around, it sounds nefarious. So here, the head of regulatory affairs, who was there at the time they made the statement, said that they didn't do, it wasn't a regular post hoc analysis. They acknowledged that post hoc analysis can be useful, but what they did here was reprocessing it to make it look better. That is different. But second of all, even if you look at Kleinman and Carrick's is the one that talks about, oh, you don't have to talk about how many post hoc analyses you did. But again, Carrick's involved a situation where they simply disclosed the results. They did not come in and say, oh, we did this post hoc analysis and then we did another post hoc analysis, right? It's a situation like if I described a magic trick to you and said I did a magic trick and somebody picked the card out of the deck and they don't tell it to me and it was the ace of spades and then they put it back in the deck, shuffled it up, and then I picked it and then I went and I pulled out the ace of spades. That sounds impressive until I tell you it was the 34th try. Right? There's a big difference between how impressive that is, and that's what defendants didn't disclose. They might not have had to have originally stated the details, but they chose to get in there and tout the positive results of these two analyses without going into the fact that they had reprocessed the data to make it look better. As to the issue, and there's a number of cases that talk about this issue, and they talk about it in a number of different ways, about touting the positive while not disclosing the negative. You have Meyer v. Jinko Saylor out of the Second Circuit, where they touted their practices on pollution and about how important they are, but didn't tell you that they were in violation of the law also on those. You have the cases that go to, I think it's out of the Ninth Circuit. It is the case...
Well, I assume that they're in your brief.
It is, in the Schunemeyer case,
So,
talking
right,
about
you
the
don't-
positive and
I was
negative.
going to say on rebuttal, you don't have to
Sure.
cite all these cases, just you need to make your points and finish up.
Right. Under the issue about CW1 not being at the company at the time of the post hoc analysis, that's not what the pleading requirements require, even at the heightened pleading standard. The key that the courts always talk about, and these are 10B cases, a higher pleading standard, has to do with whether or not you were there at the time the false statements were made. And that's exactly what CW1 was doing. And you, I believe one of your honors had talked about this having to do with the risk analysis. One of the things about the risk analysis showing that the investors didn't understand the true risk is, remember, when the drug failed, the phase 3, stock plummeted 70%. That doesn't sound like people that were investing who knew that this was doomed to failure like the company knew inside. Unless your honors have any other questions, I'm happy to rest on that.
Any further questions? Thank you. Thank both of you. Interesting argument.
Is this yours?
Polonia versus 14 Sutton Tenants. All right, you may proceed.
Good afternoon, Your Honors. My name is Tim Norton on behalf of the plaintiff appellant. This is a labor law action. The facts are undisputed that plaintiff appellant fell from a scaffold that lacked any protection. There were two scaffolds, two
Fell from
scaffolding.
one part of the scaffold to another part of the scaffold, right?
That's correct. It was a sidewalk bridge, and there were two separate scaffolding platforms, and it's undisputed that there was a 2 to 4 foot gap between
And the reason he fell wasn't because of the gap, right? It was because he tripped over a plank.
Well, he testifies that he's a foot from the edge of the area where there's a gap between the two scaffolds.
And he also testified that he tripped over a plank, right?
That's correct, but it's irrelevant to whether or not there's a labor law violation here. Our argument is not that there was a violation with the planking itself, it's that there was a gap between the scaffolds that he fell over. So whether he trips or falls or any way over that gap, the elevation-related risk between the two scaffolding planks is what the violation of the labor law is.
There's no evidence that the gap between the two, if there was any, was the cause of his fall, right?
Your Honor, that's not consistent with the way that this department has treated a scaffold fall. The Vergara case clearly states that whether the scaffold tips over, whether there's a trip and slip from the scaffold itself, the violation is the fact that the scaffolding itself failed to protect against the elevation risk. So whether he trips just immediately preceding the gap is entirely irrelevant.
Well, it kind of did protect him because it was bordered so that if he had fell off, first of all, it's a sidewalk bridge. It's not a scaffold, right? My understanding, it's a sidewalk bridge. And it was bordered so that if he had fallen off of the sidewalk bridge, clearly that's a 240 violation. But this is where he tripped and fell from one level of the sidewalk bridge to another level. So it's like walking on a sidewalk and you're tripping and you fell.
I don't think that's accurate, Your Honor. He's 10 feet in the air on a equivalent of a scaffold.
I get
and
that.
It's a sidewalk bridge is, the terminology is.
I saw it. I saw the picture of it because I had to go take a look at it.
The Hernandez case from 2012, this court specifically said that the configuration of a scaffold that required workers to travel across an unguarded gap of 3 feet was an inadequate safety device.
But he doesn't claim that the gap is what caused him to fall. He claims that he fell over the plank.
But, Your Honor, in Gomes, this specific issue was again addressed by this court where the allegations were two versions of the accident. One was he tripped on a block and then fell from a scaffold. And the other allegation was just that he slipped and fell from the scaffold. The fact that he tripped on the block prior to falling off the unprotected edge doesn't negate the proximate cause being the lack of an adequate safety device here.
The gap that we're talking about, the gap is the differential, it's the height differential from one level of the sidewalk bridge to the other level, right?
That's correct, but that's consistent with case law from this department where one scaffold plank to a lower scaffold plank less than 5 feet was considered an elevation-related risk. We cited that case in our papers. I don't even believe the plaintiff fully fell in that case. His foot fell to the lower level as opposed to his whole body falling, and that's in our reply brief.
Yeah, we'll look, we'll find it, yeah, okay.
It's Graminga versus Moore's Diesel. And this court said that the 2-foot height differential between the two levels of scaffolding and further distance that the plaintiff's left foot was caused to fall entails an elevation risk. So even between the two scaffolding platforms, say, you know, this isn't a sidewalk bridge, this is just a regular 2-platform scaffold, falling from one level to the other 2 feet, this court has said, is an elevation-related risk.
In this record, I just don't see any evidence that the differential in height had any impact on either the cause of his fall or the effect of his fall. Is there any evidence to support that?
Yes, he suffered severe injury by falling 2 feet, and he had numerous back surgeries as a result of this. But, Your Honor, again, Vergara tells us that the precise manner in which you fall from an inadequate safety device is irrelevant when considering proximate cause. The only way it would be relevant that he tripped is if there was no elevation risk that was to be protected against. If he fell from the same platform, which I think is cited in the papers here, yes, that'd be a different scenario, but the risk that they didn't protect against was the risk between the 2 to 4 foot gap between the scaffolds. There's testimony in here, at the very least, I believe that we're definitely entitled to summary judgment, but at the very least, there's issues of fact as to whether or not they should have used a ramp as they had used in the past on the site. CM's manager...
Well, what would the ramp have done?
The ramp would at least provide a means of safe escrow from between
But he fell before he got to the point at which the scaffolding was gapped with the other scaffolding. A ramp wouldn't have changed anything here.
There's multiple alternatives. A ramp was just something that they were using to transport materials in the past because they had noticed that
But what would it have done? You know,
they could have used
talking about safety devices.
They could have used a railing.
I'm just trying to unwrap my head around.
Sure.
What safety device would have otherwise accounted or made this fall different than it was? A ramp certainly wouldn't have done.
They could have used a gate like they use on a regular scaffold when you have platform gate.
How could a gate have, assuming that a gate was required, it's not clear that it was, but assuming that a gate was required, if he fell, he would have, I don't understand why the gate would have been a safety device. You're saying the gate would have broken his fall? What would have happened?
When you have a scaffold and you have a platform rail, in an area to obtain access to the platform rail, there's a gate to enable access that could have been used here.
We understand that, but I'm just talking about the mechanics of this accident. What safety device would have changed the mechanics of this accident or alleviated the effect of this accident? What safety device?
A safety railing would have, or constructing the scaffold in a way where there's not a 2 to 4 foot gap in and of itself was their responsibility to do so.
You don't dispute that that structure was approved by the city, right?
Whether it was approved by the DOB is irrelevant for my labor law claim. The Court of Appeals in Zimmer and this court in Vasquez has said the circumstantial reasonableness plays no role in the analysis related to the failure to provide safety devices when the circumstances warranted. Zimmer tells us industry and custom doesn't matter. What matters is this something that's a foreseeable risk in order to protect against? It's clearly foreseeable that someone could trip trying to access a 2 to 4 foot gap. And again, I understand Your Honor's point that he tripped prior to that, but again, the testimony is he tripped a foot or less from the edge. So I think it's very unclear to say the trip in of itself is the entire hazard that we're looking at. We're looking at a hazard of trying to traverse between the two separate scaffolding planks. And there's an elevation risk, and this court has said numerous times that a 2-foot drop or a fall is a significant elevation-related risk.
Okay. All right. Thank you.
Good afternoon, Your Honors. Corey Puglisi for the respondent, 14 Sutton Tenants Corporation. I know I only have 1 minute, and I'd just like to point out that the majority of the cases cited by the plaintiff do say that a plaintiff need not allege the exact cause of his or her fall. But when a plaintiff does allege the cause, and in this case he alleged he tripped over a plank of wood, then he's stuck with that characterization of the accident. And on
The counsel seems to allege, though, that the plaintiff's injuries were exacerbated by the gap in height between the two parts of the sidewalk bridge. Do you agree that there's support for that in the record?
I don't. I think it's pure speculation. In fact, the plaintiff never even mentions a ramp in his testimony or anything like that. That comes from the testimony of the sidewalk shed contractor who said there may have been a ramp, and if it was there, it's because guys were using a wheelbarrow to transport bricks. And in this case, the plaintiff was just walking across the sidewalk shed to retrieve tools. And on page 553, when he's asked, do you know why you tripped with your left foot on the 2x8? Because I wanted to do my job quickly, just going fast to go do my job quickly. And for the reasons already discussed, we feel that the lower decision should be affirmed. Thank you.
Thank you.
Your Honors, may it please the Court, Mohammed Ayub on behalf of Respondent Central Construction Management. Not to rehash or beat a dead horse, but the proximate cause of plaintiff's accident was him tripping over the non-defective plank, which comprised of the platform of the sidewalk shed. There was no gap, there was no opening.
Well, there was a gap to the extent that as there were two scaffolds, and one going to the other, one was higher than the other. True?
It's our categorization that it was one L-shaped scaffold, sidewalk shed rather, that
Sidewalk shed.
wrapped around the corner.
But it didn't wrap around seamlessly. There was, in fact, an elevation difference when the scaffolding turned the corner, right?
The elevation difference basically amounted to a step, a de minimis
Whatever
step.
it was, elevation is elevation. We may differ on the quantification, but they weren't flush.
They were not flush. They were conforming to the drawings, which were approved by the Department of Buildings.
Understood. We already talked about that. I'm going to ask you the question my colleague asked your co-respondent, which is there anything in the record where the plaintiff claimed that the elevation exacerbated the nature of the injury that he suffered so as to be a cause of it?
Not that I'm aware of, Your Honor. I think you brought up a good point earlier where that even if there was a railing, he would have tripped into the railing. So that's by that same logic, even if there was a railing, the injuries would have been exacerbated by the presence of a safety railing in that.
Well, we don't know. It's all just speculation.
Sure.
Certainly a ramp would have made a difference because he was propelled forward.
He was propelled from one portion of the sidewalk shed to the other. In this case, there happened to have been
From the higher to the lower.
a step, right. He didn't fall off of the sidewalk shed. He didn't fall off the edges of the
understand,
sidewalk
but he was hurt. I mean, right. I mean, so that's not the nature. He did go from one platform to another platform. I don't know that a ramp would have made a difference.
No, because he would have fallen onto the ramp itself.
Or not, or beyond the ramp, I don't know.
I mean, your focus here is he tripped on a plank that was not defective, and there's no dispute it was not defective. He tripped and fell, as opposed to where he was trying to get from one level of the sidewalk bridge to another level of the sidewalk bridge and injures himself. That would be a problem for you.
That's essentially what the argument is, that the proximate cause of the accident wasn't him traversing from one level to the other, it was him.
Because that would have been more problematic if he was going from one level to another level and he injures himself.
Not necessarily, Your Honor, because, again, not every fall, not every gravity-related...
Yeah, no question.
And it's actually
I just think it would
interesting
be
why
a little bit of a problem.
It's interesting why the plaintiff uses the term ramp instead of a staircase, because essentially plaintiff is asking the court to basically pass jurisprudence that, a railing would have to be put at every staircase at every job site to prevent, gravity-related risk from causing those types of falls. As to the Labor Law 200 claim, plaintiff, the lower court properly dismissed that claim as well. My client was a true general contractor. We hired subcontractors at the site. Plaintiff was working for New Life. Plaintiff took all of his direction and supervision from his foreman or the owner of New Life while my client had a degree of control over the site. It certainly was not the requisite degree of control. And as, by the same token as what we're arguing with respect to the 240 and 241-6 claims, it's our position that the sidewalk shed was not defective. There was no dangerous condition of any kind. There was certainly no notice of any dangerous condition, and my client did not create the step. It was installed by a third-party defendant, Interlife Systems. So unless the court has any other arguments, questions rather?
Yeah. We noted you said arguments. No, we have questions. We don't have questions. We're good. You have arguments, we have questions.
I do.
Right?
That's
Okay.
right, certainly.
All right, let's hear from the plaintiff's attorney. We'll give
Thank you,
him
Your Honors.
rebuttal. Thank you.
Just in response to the question.
Counsel, I've been rereading the plaintiff's deposition, and I just don't see anywhere where he says that the differential in the height caused his injuries to be worse.
He does, Your Honor. On page 598, there's a question and answer. The accident, did you ever complain to anyone about the height differential that existed between the two scaffolds in the sidewalk bridge? Never. But for somebody who would be conscious that this kind of work were being done, and you would have to exert your strength as you pass by, that should have been placed there. What should have been placed there? A small staircase should have been placed there, or something, or at least 3 steps or something like that for people to walk on. He's clearly describing the fact that there were devices that could have been placed.
But that doesn't describe that his actual fall was in any, or injuries were in fact caused.
He also
by,
says that.
Excuse me. I don't see that page answers the question I asked you.
He also says that he fell on his left side on the other scaffold, and his injuries were the result of falling onto that other scaffold on his left side. That's clearly throughout his testimony. So I don't see how that's attenuated. That's clearly responsive to the actual hazard here, which is the fall from one scaffold platform to the other. The tripping is entirely a red herring. And this court said specifically that.
But what would the steps have done? He fell before he got there. He would have fallen over the steps. What would they, or a ramp have done? That's really what I'm, in my head, I'm trying to visualize what's going on here.
I understand, Your Honor, but it's very clear that the plaintiff doesn't have to show a feasible safety device in order to gain the protections of Labor Law 240 as well. That's been outlined clearly in.
But it can't be kind of an imagined safety advice. It has to have some nexus to the accident.
Your Honor, if they would have constructed the scaffold properly and not had a 2 to 4 foot gap, if the scaffold connected on one level.
Well, that's a different issue. And I didn't see in your papers anywhere that there's a requirement that this wraparound sidewalk shed needed to be a connected flush.
There absolutely is a requirement in the case law that says a sidewalk bridge or sidewalk shed it has to be constructed in order to provide proper protection to plaintiff.
There was no expert testimony as to that, right?
There is no expert testimony, but it's been held countless times from the Court of Appeals and especially in this department.
Well, that's a general statement, but we're talking about the idea. Because this is, this can't be uncommon, where a building is doing work and there's scaffolding on different sides, that the scaffolding wraps around the building, and there doesn't seem to be at least any regulatory requirement that those scaffoldings be flush, or that they have steps, or that they even have a ramp. I suppose as a practical matter, depending on what that gap is, it might make sense, but then again, we get to what difference would it make in this particular case, and I just don't know.
First of all, there is testimony here.
That was rhetorical, because you're right, because we're going over the same ground.
I'd just like to add one more time, the Hernandez case.
No, don't add one more time. No repeats. Go on.
Well, I didn't know if it was clear. I'm sorry.
It's a long calendar, no repeats. If you have something new to add, I'm happy to hear it. We are familiar with your case, clearly.
The 3 foot gap, and navigating that was considered an elevation-related risk.
Okay, thank you. Matos v. Geraldo. Okay, you may proceed, Counselor.
Thank you. May it please the court, Kenneth McCallion for the defendant appellant, Stephen Geraldo. There are basically three grounds why this jury verdict should be set aside and a new trial ordered. And frankly, in their papers, the other side, the plaintiff's counsel, did not necessarily disagree with our analysis that there were legal errors. They more had an issue with whether it was harmless error or so prejudicial that a new trial should be ordered. Specifically, the first ground is that the court took judicial notice of a stipulation entered into in another proceeding where none of the parties in this case, neither the plaintiff nor the defendant, were a party. This directly violated the provisions and the requirements of the statute and case law under CPLR 4511 for the taking of a judicial notice, which requires that the court proceeding, the order stipulation in the other proceeding, be binding on the parties in this case where judicial notice is taken. And secondly, that it be relevant. In this case, there's really no question and no real dispute between the parties that the stipulation, which the court took judicial notice of, was not binding on the defendant in this case or the plaintiff. And there's no case that we're aware of, and apparently the other side isn't aware of a case either, or they would have cited it, where judicial notice has been taken of a stipulation court order in another case where neither side, in the case where it's taken judicial notice, was a party. The trial court appears to have been confused as to this issue. On the record, it has said repeatedly that it believed that the stipulation in the landlord-tenant case between defendant's father and the building administration, building management, was a stipulation, was part of the history of both parties here, referring to the plaintiff and the defendant. And it was perhaps a good faith error by the court, but a clear-cut error. He should have never taken judicial notice of it.
Okay, you're going to have to wrap up your argument.
Sure.
Your light is on. And you have no adversary here.
Well, we'll certainly...
We do have your briefs, honestly, so it's, you know.
Yeah, if I could just point out in the closing argument, the defendants argued on their brief that there was no objection made to this reference to this landlord-tenant matter in closing argument, which the plaintiff's counsel structured his entire argument and his closing around it. That is really the prejudice. The only evidence in this trial was the testimony of the two parties and essentially the judicial notice, which was taken just before closing argument. And the plaintiff, instead of structuring it around the issue like the prior criminal case we had, where the issue is, were they facing each other or was he hit from the back? Those were the relevant issues in a personal injury case. In this case, the case was transformed into an issue as to whether the defendant's family owed money to this particular building. Extremely unfortunate. The jury result here is anomalous.
I'm going to say with all due respect, but I've asked you to be mindful of the time. And you're not being mindful of the time. I respect that you're passionate about your case, And I don't want you to misunderstand, because the fact that we have busy calendars doesn't mean that we don't read the briefs and we don't give them fair consideration and we don't discuss the issues, which we would surely do. Okay?
I appreciate the court's
Okay.
consideration. Thank you.
Thank you. Castillo versus West End Towers.
Good afternoon, Your Honors. May it please the court. My name is John Shore, and I represent the plaintiff appellant. Respectfully, the lower court erred when it held that the commercial window washing work that my client was performing was routine maintenance. Under the Bragi case.
Counsel, if I may, how is this not routine? Castillo was directed to clean the windows every Saturday using paper towels and Windex. What is non-routine about that?
It is no different than any other type of window case, which has been considered to be a protected activity. It is
Counsel, with all due respect, you didn't answer my question, and then I have another question once you answer that one.
Okay.
Because what was the special equipment other than paper towels, Windex? Did he do training? So can you answer like A and B?
Right. Again, respectfully, Your Honor, there is no different special equipment than all the other cases. In Bragi, there was no special equipment. They were doing interior window cleaning. They were using window washing soap. That is not the point, respectfully. In Swiderska, which was not a window washing case, it was a Court of Appeals case, the plaintiff was using a rag to clean the windows. That was the only equipment given to the plaintiff, and the plaintiff was on using a piece of furniture. The issue is whether or not it's an elevated activity.
Wait, are you saying, counsel, that anytime anybody washes a window in a business, that's covered by the law?
Not necessarily, Your Honor.
Okay,
I'm not saying that at
all
all.
right. So then we're up to the 4 factors, right? Because this is not a commercial window washer that gets paid once a year to come in and clean the windows. This is somebody who is told every week, one of your jobs is to go outside and clean those windows. So then we get to the 4 factors, correct?
Well, again, I respectfully disagree.
Well,
Before we even get-
either you are saying that every commercial window washer is covered, or you're not saying that, in which case you are saying, then I get to the 4 factors.
I also do get to the 4 factors, but every commercial window washer is covered if they're doing a storefront. This is not routine.
I don't think, that's what I'm saying. That's what I disagree with you. The proposition that anytime you clean a window in a store, you're covered by the labor law. That is clearly the Court of Appeals that said that's not right.
Well, it depends on the circumstances, Your
Exactly.
Honor.
So now we get to the 4 factors.
Okay.
So tell me why the 4 factors favor your client as opposed to the defendant, because that's what happened here, right? That's what the lower court did. And what did the lower court get wrong?
What the lower court got wrong is that this is not simple household cleaning. My client was cleaning a storefront.
Again, so then we get back to either you're saying that anytime anybody cleans a commercial premises, it's covered by the labor law. I thought we just agreed that that wasn't right. So let's get to the 4 factors.
Under the Soto standard, this was not routine maintenance. This was someone who was cleaning, who had to clean, get up on the 7th, about the 7th level of a ladder. This was up
Yes, I'm not saying that that's not a risk, but the question is whether it's strict liability under the labor law, and that's a different question.
I understand
Right?
that.
And
It
so
is-
again, I'm saying to you, are you saying that anytime anyone cleans commercial windows, that it's covered under 240 of the labor law? You've said, I thought we agreed that it wasn't. So then we definitely are going to the 4 factors.
Again, the 4 factors, it clearly falls in within the 4 factors, and it falls within Bragi. But under the 4 factors, if you look at Swidersker, that case is very similar to this case, as well as the Fox case. The Fox case was a maintenance worker similar to my client, and all he was doing was power washing, and the elevation was deemed to be critical.
But in that case, for example, a power wash machine is not a rag and some Windex. So that was one factor that the court looked at in the 4 factors to say, well, these 4 factors, if we look at them all, one, particularly because the guy's using something that you don't generally use to clean, and that's one of the factors that weighed in favor of the plaintiff. So
In a recent case,
in your case, you had somebody who was told every week to clean the windows. It wasn't something he did once a year or every other year, correct?
it was part of his job, but
Okay,
respectfully,
let me go through the 4 factors.
Okay.
So was it routine cleaning? Yes, because he was told every week you got to clean the windows. 2, was he using specialized equipment? No, right?
none of the window cleaners in the cases, even in Bragi, they were doing interior work, and in Swidersker, it was someone who was just using a rag. A critical thing was the elevation. In a recent case, Your Honor, that you were on the panel in Durazno, where my client actually, I was the plaintiff's lawyer. It was a recent decision.
I remember it.
You're
we
very
talked, we
familiar.
said there was a issue of
Was-
fact as to whether or not the
Right.
labor law applied.
And the
right?
lower court, right. And
But
we were,
here, every case has to go under its own facts, right? In this case, correct, the front windows are the windows that he would wash. And yes, I agree. Was there an elevated risk? That's one of the factors. That cuts in your favor. But there are 4, not 1.
in the Durazno case, well, of course, it was a question of fact whether or not he needed to use a ladder. He was a maintenance worker, and the defendant said it was a routine thing. And the critical thing, again, was the elevation. He worked for the Gap. He was a maintenance worker.
I remember the case,
Right,
and the
and there was
question
nothing-
was,
there
the
was
question
less
was
grounds.
whether the statute applied. That's
There-
what we held.
Right, there was
There
less
there was
grounds.
nothing more than that, whether the statute applied.
This was not, if I accept Your Honor's opinion, if this was someone who was just washing someone's house with a rag. Here, my client, again, I know we're talking about the elevation. This was something that is not the normal routine household work. He had to do 2 storefronts, and none of these require licenses or special expertise, as there's no difference in the Swidersker case. A critical thing was the elevation. That person was just using a rag and had...
Well, it wasn't in that case they worked for a commercial contractor.
They worked
The problem is, here's the problem, really, and I understand your argument, but in a certain way, these cases are like snowflakes, and they kind of turn on their own facts. And while there are certain similarities with Swidersker, unmistakably, I'm not sure that they're identical. But let's hear from your adversary. Thank you.
Good afternoon, Your Honors. May it please the Court, Anthony DiStefano for the defendant respondent, West End Towers. So 3 of the 4 SOTA factors were discussed. Routine frequency, it was once per week. Specialty equipment, there was none.
Not every factor, no one factor is determinative,
And no
right?
one factor is
They're
determinative.
snowflakes, these cases, right? That's a fair
Exactly.
assessment.
Exactly, Your Honor. And with respect to Bragi and Swiderska, both of those cases predate the Court of Appeals decision in Soto by a few years. So
Yeah, so
whether or
did
not
the Fox case as well, right?
Yes, and as Justice Scarpula pointed out, the Fox case involved a power washer, so that distinguished it as well. So here, the court looked at the facts of this case, looked at, again, frequency once per week, whether or not there was special equipment, none, whether or not it was common to household elevation-related risk. Well, maybe 8 to 9 feet is a little bit greater than the common household elevation-related risk. Last factor, was there any ongoing construction? Answer, none. So 3 of the 4 factors come down in my favor.
But the elevation did not, clearly.
The elevation did not. The court looked at this as a whole, made the determination that this was routine, that this is a commonplace activity that is done in countless storefronts throughout New York City on a daily basis, and for that reason found that it was routine work, unlike Durasno, where it was, I think the plaintiff in that case had testified that in the year that he had worked for the Gap, that work had never been done in that year. So that was clearly not routine, and clearly it involved a much greater height differential. So the court again looked at the factors, and although this court did not cite to Soto, clearly the analysis comes through that the Soto factors were at least a question of fact in that case. So here, again, applying it to this particular case on these facts, these 4 Soto factors come down in our favor, and for that reason, we ask the court to affirm.
Thank you. Okay, we'll hear from your adversary on rebuttal.
Again, respectfully, this case hinges on the fact that this is not someone just cleaning the window with a rag. This is someone who was
cleaning it with a paper towel.
Same thing
Right,
with a rag
right.
in
Yeah,
Swiderska.
I don't know that really, right, that
Right.
that
And
doesn't
then-
cut in your favor.
And in fact, my adversary argued, well, they had a professional cleaner
Right,
who was
Swiderski,
doing
they
it.
did it was a
That professional
company.
cleaner was using the same equipment that my client would be using, and the same thing
But it was
that-
a company that was called in to do it, so it wasn't regular, that went to the routineness, didn't it?
Whether or not it's a company or not is irrelevant. It's the fact that they were doing the work of a company.
So that's, again, what you're arguing basically is anytime someone washes windows that are above their head, the labor law applies. And that's exactly what the Court of Appeals has said is not correct.
That the Bragi case specifically said that this type of situation is commercial window washing. It doesn't matter the title of the person. None of these people have licenses. The person in Swiderska was a cleaning person.
So again, that your argument basically is
was-
that anytime you wash a storefront window, it's commercial cleaning and therefore covered.
It's commercial window washing, and the elevation itself in Durasno, he was a maintenance worker. There was nothing different, and this court reversed the lower court and held that it was a protected
You're saying that
activity.
the elevation is outcome determinative under Soto?
The elevation in a commercial context like this, where someone is not just cleaning, again, their house, they're working on a storefront where they have to work on 9-foot-high windows, and they had to use a ladder. That is clearly not what is considered routine household maintenance, regardless of your title here, because none of these people had any more expertise than my client. It's the elevation and the type of work, and putting them in a situation like that. It was not
We understand your arguments. Thank you. Thank you both. I always give special thanks to the last case on the calendar, because you need to wait in the court as long as we've been in the court, so I appreciate your patience.
Have a good evening.
You too.
Thank you.
You and I are going to have together. You did. I don't think this one is supposed to be no. Okay.